May I be permitted to mention one matter, my lord? Second appeal, ready for hearing 2014's matter upon service notice to the other side, my lord.
You are for the
Appellant, my lord.
appellant.
Yes, my lord.
Paper book ready?
Yes, yes, sir. Everything is ready. That was running in the your other coordinate bench, and thereafter, after change of determination, matter is out. Grateful.
What you for including the list under heading 2 matter or correctional order, small correction.
Okay.
May I permit to mention one matter, my lord, for inclusion of your lordship list in old second appeal, my lord, 1993, my lord.
You are for the appellant?
No, respondent.
Respondent.
Yeah, I
Who
have
is for
served
the
the
appellant?
notice.
You serve.
Yes, my lord. I have
Is the
served.
matter ready or application is there?
Application is there.
What application?
Application for substitution. My client, my lord, died, my lord.
So the application must be for the plaintiff, for the appellant.
Yes, my
It was not disposed of
lord. No, they have not served any.
under the heading application. You are for the appellant. One is for injunction, another is
Yes, been harassed by the tenant and occupied the place, occupied the
so what is your prayer there?
that I have the petition for hearing.
Hearing for what application? What is the relief you want?
Application.
Okay, take the both the applications.
What happened? If lordship matter received the matter, if the appeal was filed later, and directed the matter to the regular. Well, the order is there. One of 20 leave the matter.
This is second appeal.
Second appeal of 2024.
I don't have the determination.
The matter is
I don't have the determination.
but if lordship said that your lordship has got the determination, the appeal was
You see the list.
I know, my lord. I asked.
I have said
Because I am going
2017.
to-
No, that is not the way. I have the I don't have the determination. How can I hear you without jurisdiction?
Lordship directly.
Tell his apprise his lordship that I have the determination.
I repeatedly told him.
Then go to the chief justice.
I went to the chief justice. Well, I went to the secretary of the chief justice.
Make a special assignment for this court. Otherwise, I cannot. This is 2017 is my determination.
The order is here, my lord. I repeatedly told the lordship that.
How can I do? You know that that is not the correct. That is no, you know that is not the correct.
I know. I repeatedly
So what shall I do? I also doing the same mistake. You want?
No.
Then-
What I subject to correction, I am not the other. Let the matter as a
How? How that may be?
A judicial order is here.
Maybe judicial is there. How can I allow you to take the list which is not within my determination?
Even I went to the secretary, my lord, to order the secretary for attaching.
You
Already-
we went before the chief justice. You go.
Before that, there is a let the matter actually before lordship.
No, no. I cannot. I cannot take up the matter.
My lord, what can be done, my lord?
You go before the chief justice.
I've been to the chief justice, my lord.
You read the list. I
know,
have
my lord,
determination only 2017. Up to 2017, I have the,
my lord, that is the filing taken from the court. Therefore, this lordship also taken the filing of the statement of year with the court. I
so
repeat,
what is the number?
number is, the filing number is AC 83 or 24. Well, the appeal initial order of appeal was AC
7?
90 of 2004.
Then why you are arguing like that? Then say so. That is within my determination.
Sorry, ma'am.
What is the matter?
Matter is, my lord, we dealt with litigation suit and injunction, my lord.
You are,
I am from the respondent.
have you served notice upon the?
I the other side, my lord.
No, no, not intimation. You have to serve the notice.
They let
No, you serve notice and come.
I comment you.
Wednesday.
My lord,
You serve notice and
My
come.
lord, be permitted to mention for releasing the matter, my lord, I mentioned on Friday as well. My lord asked me to come
For
on.
releasing the matter.
Yes, my lord. My
What
lord,
matter?
this is a foreign trade matter.
Okay, the order has been passed, I think.
No, it was a previous, it was a different matter in which my lord
Okay.
decided that my lord does not have the determination.
My lord, may I,
Let me mention.
my lord, may I be allowed to mention? My lord, this is a first miscellaneous appeal of 2007. The appeal has been disposed of. I am the respondent, decree holder. The appellant has deposited the decretal amount. This arises out of money suit, deposited the decretal amount here, which is lying with the learned Registrar General here. I have made an application for withdrawal of the same.
Yes.
My lord, I am playing a application in connection of the application number 769 of 1990. My lord, I filed.
You are for
I am for the applicant herein.
applicant.
Yes, my lord.
Have you served upon other
Yes, my
side?
lord. I have already served the
What is
notice.
the application is there?
Application for recalling the order. Since my lord, without disposing the my lord restoration application, the honorable justice that call for the record, pass the order, call for the record, and final hearing the matter. How can it be? I mentioned before the honorable court, but honorable court requested me to mention before the regular bench. I also mentioned.
Is the amount was in that pending stuff that matter you have gone on to respond to okay, what can
Application.
My lord, may I leave to mention one second appeal for inclusion in the list under the heading hearing
Second appeal for the year
2020, 2003
2003. You are for the appellant.
appellant. I served the notice to the other side and the court.
Have you served it?
Yes.
Matter is ready.
Yes, and subsequent coordinate bench twice heard, thereafter determination change and the matter was gone.
Okay.
Everything is ready.
information.
You are for the appellant or respondent? Have you served respondent? Yes.
My lord, may I be permitted to mention a second appeal of 2004? The matter is ready for hearing, very old matter. I have
Is there
intimated,
any applications?
no applications.
May your lordships kindly mention item numbers 48 and 54 if lordships listed, my lord. These are notification matters, my lord. I was humbly praying, my lord, if they could be listed under, my lord, mention matters as your lordship generally does.
44,
And 54.
44 and 54.
So 48 and 54.
48 and 54.
Yes, ma'am. Oblige me.
If not taken up today,
Yes. If not taken up today, my lord, then under
okay.
mentioned matters. Oblige me. Deeply obliged.
Call the matters.
The matter relates to, my lord, deduction of huge amount from the bill of commission of the wholesaler.
Yes. Is there any instruction?
No, your lordship.
Very well.
We have to kindly turn to the last page of the petition, page 59, second paragraph. I am disputing this amount because huge amount, page 59. According to them, total dues were 71 lakh and odd. 28 lakhs have already been deducted. Now, according to them, 43 lakhs 80,900. I am disputing this amount because huge amount of goods, despite my repeated request, they have not lifted. Although, my lord, the commissioner directed the directorate after hearing me that these goods should be sent to the other distributors. That has not been done in my Chetla godown. There are 2 godowns. I'm running my business. So far, the Chetla godown is concerned, my lord, 3 areas have been dealing from me.
Yes.
Goods were there. That's my case. And if you like to kindly see the one order of the commissioner. Page 29, just 2-3 paragraph I shall show.
Page 29.
My lord. They have been tagged
initially with me, then delinked from North Calcutta. Kindly see, my lord. Amma Street, Maniktala and Bodobajar. Page 29.
Yes.
Now, your lordship, kindly turn the page my lord, 31.
No, this
My
is
license,
dealing order.
yes, this is delinking order. So far, this part is concerned. I am now running my lord from
Amma Street, Maniktola and Bora Bajar.
Bodobajar. Now I am running business my lord only Boranagar and Amma. Sorry, my lord. Barakpur, my lord.
Para?
Now I am running only 2 areas, that is Kamarhati and Boranagar. Now, if you want to kindly see, my license has initially been suspended. I prepared first appeal. Order has been affirmed. Then commissioner has interfered with the order, which will appear from page 31.
Page 34.
1.
31.
Last paragraph, if your lordship see, it is the observation of the commissioner, principal secretary, page 31. It appears that the appellant wholesaler made attempt to identify some of the challenge of transportation of food grains to Boranagar godown, claiming that those were in fact transported on Chetla godown. I kept some goods meant for Boranagar godown in Chetla godown. That was accepted by the commissioner. If you lordship kindly turn page 32. Facts has been stated. What is my case before the second appellate authority? Then if you lordship kindly operative portion, the issue has been framed, page 34, A, B, C, D. It appears A, B, C, D, kindly see whether the Chetla godown has the sanctioned plan, whether the appellant has lawfully stored, whether there was any ill intention, whether so and so. Then, my lord, page 38, the operative portion. Suspension order has been quashed and set aside. Kindly turn to my lord, second paragraph, page 38. The appellant has stated during the course of hearing that due to labor problem, he said godown could not be dismantled at the Baranagar godown. He had to remove the approved godown at Chetla. It was initiated by the applicant intimated by the applicant that the family has been running his business without blaming since 1972. And he concerned that due to marriage ceremony in his household, he could not intimate the department in writing regarding the storage of food grains meant for Baranagar godown at Chetla godown, so and so. Then, my lord, kindly come to the next page, the order in portion. Page 39. A fine up to rupees 5 lakhs has been imposed upon me. Then B, the licensing authority shall on receipt of the proof of document of the restore the license. Then C, the appellant shall undertake further curative chemical treatment and so and so report. The licensing authority, while making the allocation of food grains, shall take into account the undisputed stock of Chetla godown. Kindly take note of this. But this is dated 11th of September 2019. Closely monitor. Then I intimated, license has been restored. Kindly turn to page 42, third paragraph. It has been curative, entire thing has been done. Quality control, give the signal. Third paragraph, then the page 43, last paragraph. Be it noted that quality control personnel of headquarters visited my both the godown so and so stocks. However, on clerical testing it in the laboratory, such stocks of food grains could not pass the sample test. Then next page, my lord. Page 44.
Sample test of what?
My lord?
Food grain.
Yes.
Lying at Chetla godown.
Yes. The meant for, my lord, Boranagar godown. I do admit that has been accepted. Then, my lord, kindly see page 44. After quality control check, I have done so, intimated the director of rationing. This is 21st of January 2020. Yes, then page 45, again intimation. No steps, ultimately, my lord, the page 59. Never lifted these goods. So this amount should be deducted from the demand of the respondents. It has been fallen from your lordship that I am accepting that 15% shall be deducted from monthly bills, but there should be a calculation of so far the goods are concerned. due to their fault, my lord, I cannot be punished. The commissioner directed the director to lift the goods from Chetla godown.
46 is your application.
My lord. Time and again, each and every occasion. Page 47 is dated, my lord, 10th of February 2020. Then after more than 2 years, first communication, page 48, 22. Then it is going on. And last communication, page 59. For quite some time, I have to keep this godown alive because this is a rented godown for only for them.
Refunds money amounting to 71 lakh.
According to them. Out of that, my lord, 28 lakhs are already been deducted. Now, according to them, the rest amount is 43 lakhs 80,000, which I am disputing. And at least 4 occasions, your lordship directed them to take instruction, no instruction, as I understood. Because they have nothing to say. To save the skin of the deputy director, this thing is going on, my lord. I must say. Despite direction of the highest authority of the state in so far Food and Supplies Department, the director did not take any steps. That document I have shown to your lordship at page 39. D and C, D and E. From Chetla godown. After proper treatment, I have intimated them that the quality control directorate has already given green signal. This is human consumable.
Page 44.
My lord. $44.45.
So you are saying in 44, 862.99.
My lord. This.
And which amount is 266?
My lord. This should be deducted.
Have been already chemically treated.
Yes.
And upgraded.
Yes. And that has been certified by the quality control directorate.
Where is the certificate?
The certificate is not with me, but I have stated that. Well, this amount should be deducted, and if she has been fallen from your lordship, that every month they may, that will also face the difficulties to my client. I am standing on 10%, but since it has been fallen from your lordship, 15% per month. And from August, September, October, November, December, I could not place the bill, because if I place the bill, entire amount shall be deducted.
Yes, Ms. Sina. What can be done?
On the last occasion when this matter was taken into your lordship, I don't know whether Mr. Chatterjee was appearing and I was somewhere else.
Yes.
A bunch of documents were handed over to me.
Year-wise, 2017-18, 2018-19, and 2016-2017, stating the quantities and how things and the audit report and how we have arrived at the
77, yes.
amount that has been. Now, when I'm hearing my learned senior friend, he says that the iota, that the balance that we have got, something should be deducted because we are responsible, according to his submission, if I'm correct. This is what he's trying to ventilate before your lordship his grievance. Your lordship, I really don't know in this matter what should be my submission. Whether the authority should be blamed and what was the reason that they did not take the necessary steps despite the order passed by the principal secretary. So my humble prayer before your lordship will be that once, if my learned friend, senior friend agrees to, let this matter again be decided or taken up by the authority. Let this be pending. Let them go for a while. If this is taken care of, then we will.
No, I am doing one thing. I am referring the matter regarding the amount of money, and till then he may be directed to deposit his bills subject to the reduction of 15%. Let the amount be decided finally by the
Fine.
authority.
Finally make this up.
Yes.
But in this case, may I pray, my lord, matter may be considered by the secretary because he.
Yes, that's what I'm saying.
Secretary.
Otherwise,
Because last time also,
yes, yes.
there was an order which was passed by the principal secretary and this was not complied with.
Yes,
So I will agree with
yes, yes. I'm
I will
getting with my learned friend. May I pray one thing? I should not bargain with the court. Can it be 10%, my lord? I'm just making it.
kindly lordship leave that for the authorities to decide. Let the principal take care of the order which was passed by the erstwhile secretary.
Yes.
May I raise the facts of the case, my lord?
No, no, I
I'll-
understand.
Secretary.
On that basis, the train had defied the order, no compliance, and that should not be taken in the amount. Send it back to the secretary, highlighting this portion of the order that they were supposed to lift, did not comply. They will decide.
Please take down. Petitioner number 1 is the partnership firm, and petitioner number 2 is one of the partner of the petitioner number 1, and have running wholesaler business. Under the license of the state respondents. Full stop. Next, for a pursuant to an order being order dated 6th of December 2018, issued by the DDR Kolkata North. Ahmad Street, Maniktola 2 and Badabazar Saveria have been delinked, and the dealing from the petitioners, and the same have been temporarily tagged with nearby distributors.
Wholesaler, my lord.
Nearby wholesalers. Full stop. Next para. Subsequently, video an order of the principal secretary and commissioner, comma, Food and Supply Department, Government of West Bengal, dated 11th of September 2019. Wholesaler license of the petitioner has been restored on deposition of penalty amount of rupees 5 lakh. Amount of rupees 5 lakh. And Deputy Director of Ration in comma, video order dated 30th of September 2019, also cancelled the previous order of delinking of dealers delinking of dealers from their wholesaler business and restored their business and allowed them to distribute the ration articles to the tag dealers of Kamarhati and Boranagar sub area. It is the case of the petitioner that for the period of 5/10/2018 to 10/10/2018, total 4055 bags containing 1999.63 quintals of rice mean for AW7 Barakpur has been lifted from Kasipur depot and stored in their Chetla road godown and for the period from 22/10/2018 to 12/11/2018, total 4635 bags containing 2331.61 quintal of wheat has been lifted from Kolani depot and stored it in their Chedla road godown. Full stop. For such long storage of good grains, the same has deteriorated. Which is curable on proper treatment, stroke cleaning, and segregation. Full stop. It is the case of the petitioner that the principal secretary in his order dated 30th of August 2019 has directed the licensing authority, while making the allocation of food grains, shall take into account the undistributed stock of Chedla godown and issue necessary indent after adjusting the same. It has also full stop. It has also been directed by the principal secretary in the same order within bracket 38/2019 bracket close, that licensing authority and appellate authority will closely monitor the distribution of food grains. So that food grains of requisite quality are distributed by the appellants to the FPS for consumption by the PDS beneficiaries. Full stop. It is further case of the petitioner that the petitioner undertook the curative chemical treatment and chemical treatment of the PDS articles. After such chemical treatment, on account of DDR North Kolkata rice 862.99 kg and wheat 2661.77 kg have been treated chemically. Full stop. The petitioner vide is letter dated 1st of January 2022 requested the Director of Rationing for lifting and clearance of the stock at Chetla Road, Godown, Kolkata. He again made a request on 28th January 2020 for lifting of such food grains. Subsequently, on 10th of February, he again wrote a letter to Deputy Director of Rationing 2020. He also make a request to the Deputy Director Rationing Kolkata North for immediate lifting of the rice and wheat from the Chedla godown. The request of the petitioner was not considered and the articles were not lifted. However, subsequently, the Deputy Director of Rationing has issued a memorandum on 16th of September 2022 containing inter alia that difference purchase price of sale price, different purchase price and sale price, purchase price and sale price of RKSY2 wheat is rupees 700 per quintal over the period from April 2016 to March 2020, comma, a total of 11,481.67 quintals of wheat was allotted to the petitioner for the for the said quantity, comma, difference money comes to rupees 80,73,169.
37.
The 80,37,169, against which it has been alleged that the petitioner have already deposited 7,01,820. Therefore, the balance amount of rupees 73,35,349 is still due. Full stop. The by the same memo, the Deputy Director Rationing has directed the petitioner to deposit the due amount within 7 days from the receipt of this letter. Full stop. It is the case of the petitioner that the petitioner has requested the authority to consider the fact that consider the fact that the Principal Secretary, Government of West Bengal, has already directed the authority for necessary adjustment, but the same has not been done regarding the chemically treated food grains lying at the Chetla godown of the petition. It is the further case of the petitioner that while the petitioner has deposited his monthly bills to the department has already deducted rupees 28 lakh 4,445 without passing any specific order of adjustment on the request of the petitioner. Thus, the petitioner has approached this court for necessary order so that the concerned authority may not deduct any amount of money from the monthly bill of the from the claim bills of the petitioner without disposing of the issue of adjustment. Full stop. On the prayer of the petitioner, this court has directed the petitioner, this court has directed the authority not to deduct any amount from the claim bills of the petitioner for the month of June and July 2024. Full stop. The petitioner has received the claim bills, received the amount on the amount for the claim bills of June and July 2024. Thereafter, they could not produce any bill, any claim bill, could not produce any claim bill as claim bill as if as on the supposition that if they produce the bill, the amount, a huge amount would be deducted from their claim bills. During the course of hearing of this matter, this court directed the authority to file a report in the form of affidavit no such report has been placed. However, the petitioner make a request before this court so that the amount, so that the 10% deduction of his every claim bills be made for the recovery of the due amount. Full stop. The state has produced a proposal to learned AGP Ms. Sinha, containing inter alia that if 10% is deducted per month from each claim bills, it will take 104 months to recover the entire amount. So hence the state authority with place a counter proposal for deduction of 50% of each claim bills for recovery of the said amount. Full stop. Recovery of the due amount. Learned
Just in the end, Lordship has recorded, just put that this is already being taken into account because there's some extra.
Yes. বলুন কি বলুন না কি বলেছিলাম লার্নেড ওটা কি বলেছি লার্নেড এজিপি না লার্নেড এজিপি সোনাল সিনহা বলছি to learned AGP Sonancia dated 11th of December 2020. 11th of December 2024. If the 10% is deducted, if 10% amount is deducted, means comma, it will take 104 months to recover the entire amount. Right? Hence, the state authority, we can place a counter proposal. Place a counter proposal for deduction due amount within 2 years. Within 2 years. Full stop. Learned, Mr. Devbot Sahara, learned senior counsel, appearing on behalf of the petitioner, submits that if the deduction is made according to the proposal of the state authority, the petitioner will suffer irreparable loss and injury. Full stop. He submits that the highest authority of the Food and Supply Department, that is the Principal Secretary, has passed a specific order upon the licensing authority for taking account the undistributed stocks at the petitioner's Chetla godown. Full stop. The undistributed stocks of rice and wheat was chemically treated. On physical measurement, the chemically treated rice weighing 862.99 kg and wheat 862.9 and wheat weighing 2661.77 kg were ready for distribution. Full stop. The concerned authority has not lifted the chemically treated rice, chemically treated food grains. Full stop. Mr. Sahara submits that the amount of the amount of chemically treated rice and wheat need be deducted from the claims amount of rupees 73,35,349. Full stop. If the state authority is allowed to deduct the entire amount, the order of the Principal Secretary as well as the value of the rice and value of the food grain, which was not lifted by the concerned authority, would be unsettled. Full stop. Mr. Sahara paid for necessary direction upon the authority for deduction of the amount of such food grain from the claim amount, from the due amount. Full stop. Ms. Sinha, learned counsel, learned AGP, submits that it is uncertain why the concerned authority has not carried out the order of the Principal Secretary, Department of Food and Supplies, Government of West Bengal. It further submits that the authority concerned, though has come to a specific proposal for deduction of 50% amount of each claim bills for the recovery of the due amount, but the same may be referred to the concerned authority again, concerned secretary again, secretary again for proper redressal of the petitioner. Full stop. Having heard the learned counsel for the party, it appears to me that the petitioner has successfully placed a case before this demonstrates a case before this court that in view of the order of the principal secretary, Department on Food and Supply, Government of West Bengal, the distributorship, wholesalership license of the petitioner was restored with a fine of rupees 5 lakh. Full stop. By at the time of restoring the license of wholesale business of the petitioner, the principal secretary has also directed the licensing authority to take appropriate steps about the allocated food grains, allocated and undistributed food grains, and undistributed food grains stocked food grains at the stock of Chetla godown, within the stock of Chetla godown of the petition. Full stop. It further appears from the document that the that a huge amount of rice and wheat were chemically treated and were ready for distribution to the authorities, distribution to the PDS beneficiaries. Full stop. The petitioner has made several requests to the concerned director of rationing for lifting of such food grains, but it appears that the reasons unknown to anybody, the said food grains were not lifted. It appears to me that the present petitioner cannot be blamed for the conduct of the concerned rationing authority for not lifting the food grain from the Chetla godown, at Chetla Road, Kolkata. Considering the same, it appears to me that the calculation of due amount of money, that is rupees 80 lakh 37,169 due difference amount of money rupees 80 lakh 37,169 as calculated by the state authority appears to me improper. However, I think it necessary to refer the matter for proper calculation and for taking proper decision of the matter by the authority concerned. In the light of the order and direction of the Principal Secretary, Department of Food and Supplies, Government of West Bengal, dated 11th of September 2019. Full stop. It is directed that the present petitioner shall approach the authority for proper calculation of his differential amount. Also, the appropriate authority shall take the decision within 6 weeks from the date of receiving of the communication by the petitioner, by giving a proper opportunity of hearing to the petitioner. The authority concerned shall take a reasoned decision within take a decision and inform the present petitioner within 2 weeks after taking the decision. Full stop. Till then, next part. No, next part. Till the decision has been taken, till the decision has been taken by the authority, the petitioner is at liberty to petitioner is to deposit the claim bills with the authority, and on such deposit, the authority concerned is to deduct 15% per month from each claim bills for the realization of the amount. Full stop. Under the above observation, the writ petition is disposed.
The pending bill shall be released within 7 days from the date of submission. That was the previous order on 7th October. So for the August, September,
How
October,
many bills you are pending?
from August, September, October, November, December.
Okay. The authority concerned shall take appropriate steps so that the pending bills.
Not pending, I have not yet submitted.
Okay.
That's the order, 7th October order is clear.
The previous monthly bills of the petitioner may be cleared within a short interval, more preferably within 15 days
I'm with you.
from the date of submission of the bills.
I'm with you.
Lordship, date should be extended 15 days,
7 days.
7 days, 15
Previous
days,
was-
whatever.
Previous was
It will
7
be-
days.
It will be a huge amount.
It is previous
More
is 7
preferably
days.
within 15 days, I say.
That was 7 days in earlier occasion.
More preferably within 15.
And your lordship recorded
And
where my lord, appropriate authority, the principal secretary.
after,
I recorded appropriate authority.
after
principal-
submitting of bills,
Yes.
my lord,
after submitting
No,
of
so
bills,
far the consideration is concerned, your lordship has recorded the appropriate authority. It may be
Appropriate authority.
principal secretary.
Principal secretary is
Yes.
sufficient.
or
It's joint fair.
and one humble indulgence, if you're, that this
Observation.
Lordship has not gone into the merits. I just discussed with him and I forgot. Lordship has not gone into the merits of the case because
Okay.
So far this,
yes,
so far that part is concerned. The principal secretary.
I make it clear that I have not entered into the merit of this matter regarding the calculation amount
My lord.
as made out by the state authority. Full stop. The concerned authority is at leave to decide the matter afresh without being influenced by the any direction passed by this court in this order.
Concern, your lordship finally record principal secretary instead of concerned authority.
এই অপরগুলো যেগুলো বলেছে
Right.
appropriate authority সব প্রিন্সিপাল
the last order was passed by
প্রিন্সিপাল সেক্রেটারি যেগুলোই বলেছে appropriate authority all principal secretary.
My lord, get much of this. Get it.
Grateful to Lordship.
Yes.
Much.
Thank you. Next.
Get it. Without being.
I'm for the respondent insurance company, Lordship. Miss Shiva Ghosh is appearing on here.
Appellant,
Yes, Miss Ghosh, what happened?
Lordship, during pendency and after disposal of the mother, disposal of the case, Lordship, mother and father, who are appellant number 1 and 2, expired. But 3 and 4, Lordship, already they in appellant, Lordship, they are made party, and 1 and 2 is name should be Lordship expand instead of Lordship 3 and 4.
Can
Can file, I have filed. Can is there, Lordship.
And number.
can number.
1.
Give me the can. Can 1. Can 1 of 2024.
24.
আমারটা দিয়ে দাও না।
Yes.
Paragraph 3 and
No, just wait. So, some appellants has expired.
father and mother.
There are 3 appellants,
4 appellants
4 appellants. Horipriya, Lakshmi,
expired.
Lakshmikanto,
Mondol,
Vasudev, and Ravi.
Ravi.
Who expired?
1 and 2, Haripriya and Lakshmikanto. Father and mother expired. Next,
Father and mother of the deceased
3
expired.
expired.
And who are the 3 and 4s?
These are brother.
They are the
Legal
brothers.
brother.
Brothers of the
Three and legal heir of the son of the parent. 1 and 2.
sons of 1 and 2.
Annexure page 7.
Lakshmikanto expired on 2019 and Haripriya expired on 23.
Lordship, one humble indulgence, my lord.
Yes.
My lord, we have already deposited the awarded amount as the lordship granted, but lordship, the principal amount, but inadvertently, my lord, the interest amount has not been deposited yet. The check has been prepared and that will be, my lord, deposited today only. Lordship, I am praying for, my lord, will kindly regularize the deposit, my lord, that they,
Have you deposited it?
no, my lord, today I will deposit the interest portion, my lord.
Principal amount.
For principal amount, I have already deposited, my lord. But the interest amount has not been deposited. That will be deposited today, my lord. Out of time, my lord. Therefore, I am praying before your lordship, kindly regularize such deposit.
Whatever may be, if you deposit the amount, okay, you will deposit it in the name of registrar.
Yes, yes, lordship. Principal amount I have already deposited, but the interest amount
So
will
the
be
registrar
deposited.
general has prepared the check.
No, not
No,
yet.
no.
sir.
Appellant number 2 was allowed to receive the entire compensation.
Lordships.
Appellant number 2 is
2
the
is the father, lordship, but
father.
it should be mother. But lordship, I have no problem, father and mother joint. But now, lordship, 1 and 2 name should be lordship expand, and in 3 and 4 will receive the check instead of Lakshmikant Mondol.
Okay. Please take down. Can 1 of 2024. This is an application for appropriate order. Learned counsel for the appellant, Ms. Ghosh, submits that during the pendency of the appeal, appellant number 1, within bracket mother of the deceased, expired on mother of the deceased, bracket close, and appellant number 2, Lakshmikanto Mondol, within bracket father of the deceased, bracket close, has expired. Full stop. Appellant number 3 and 4 are the sole are the legal heirs of appellant number 1 and 2. Full stop. There are no legal heirs of appellant number 1 and 2 except the appellant number 3 and 4. Full stop. Accordingly, this application was filed with a prayer that necessary direction be made so that the amount of compensation may be disbursed in favor of respondent, in favor of the appellants, taking note of the death of appellant number 1 and 2. Maybe distributed to, maybe disbursed. Appellant number 3 and 4. Appellant number 3 and 4, taking note. 1 and 2. 1 and 2, full stop. Heard the learned counsel peruse the body of application being CAN 1 of 2024. Also peruse the copy of death certificates of appellant number 1 and 2. Full stop. It appears that this court, with a order dated 5th of September 2023, has directed the concerned respondent respondent NBSTC to deposit the compensation amount to the office of the Learned Registrar General High Court, Calcutta. The Registrar General High Court, Calcutta was directed to disburse the amount in favor of the appellant number 2. Full stop. It appears that the appellant number 2 has already been expired and appellant number 1 and 2 has already been expired and appellant number 3, 4 are the legal heirs of appellant number 3 and 4. Legal heirs of the deceased appellant number 1 and 2. Considering the same, the instant CAN application being CAN 1 of 2024 is disposed of with a direction to the Learned Registrar General High Court, Calcutta to disburse the check amount, disburse the compensation amount in favor of appellant number 3 and 4 equal. Full stop. Next, Learned Counsel appearing on behalf of the NBSTC stroke respondent submits that the respondent authority has already deposited the principal amount with the office of the Learned Registrar General High Court, Calcutta, and the interest portion was not yet deposited. Full stop. Respondent authority seeks necessary leave so that the time for depositing of the interest amount may be extended. Having heard the Learned Counsel for the respondent, it appears that the check amount has the compensation amount has not been disbursed yet. Accordingly, the respondent is at leave to deposit the interest portion within a week.
I'm grateful.
Within a week. Full stop. Under the above observation, the CAN application is disposed of.
That's it, just one line. Department maybe corrected the Lordship's complaint.
Okay. Okay. The department is directed to
Memo of appeal correct.
directed to correct the memo of the cause title of the appeal within a fortnight.
Grateful, Lordship.
Much obliged.
Grateful, Lordships.
My lord, I am for the respondent number 1,
My
led
lord-
by Ms. Dipchani Sengupta.
My lord, I am appearing on behalf of the appellant. Pursuant to your lordship direction, I have deposited the cost for the restoration application which your lordship directed pursuant to an order dated 10th January 2024. So, your lordship also directed that it should be informed to the court within fortnight. So, for necessary order. So, my lord, this is the original receipt, my lord.
What is the stage of the appeal?
My
Everything
lord,
is ready, paper book?
no, my lord. My lord, the for some default on part of the appellant, the records of the lower court went back to the lower court. So after the restoration is regularized by this lordship, then I will file a necessary application. I undertake to file within 3 weeks for the necessary.
How many respondents are there?
Respondent, 4 respondents are there, my lord. At present,
She is representing only one
one.
respondent.
Yes, my lord.
So you have to serve notice upon the rest respondents regarding restoration of the appeal.
My lord, restoration application before it was mentioned before the lordship, everything was sent to them.
After restoring the appeal, you have to serve.
My lord, whatever your lordship will direct, I will do that.
Okay. Paper book is ready, I think. Paper book is ready.
My lord, but the lower court's record, as I am informed, went back to the lower court. So I think for hearing the appeal, the necessary order should be passed to bring back the lower court records before this learned court, before this honorable court, and I will file the application necessary for the such order, and the cost will be borne by the appellant, my lord. This also I undertake.
Whether any substantial question of law has been framed? Do you know?
No, my lord. I have been newly appointed in this matter.
So who shall? Pencil আছে? Pencil আছে? Pencil নেই? এসে চলে গেছে? দেখছি না তো কোনো নোটিং। আছে কোনো নোটিং? আচ্ছা চলে গেছে। Okay, please take down. In pursuance to the direction of this court dated 10th of January 2025, the appellant has deposited a sum of rupees 10,000 with the Office of the State Legal Service Authority, West Bengal. Full stop. Receipt of the said deposit is placed before this court and it is taken on record. Full stop. Next para. On considering the compliance by the petitioner stroke appellant in respect of order dated 10th of January 2025, the application for restoration being Can 3 of 2023 filed by the appellant is considered and allowed. Full stop. the appeal be restored to its original file and number. Full stop. The appellant is directed to deposit the special messenger cost within a week from date for bringing LCR, from bringing TCR from the learned first appellate court. Full stop. Appellant is further directed to serve upon the, you are appearing for the respondent number?
Correct number 1.
Only respondent number 1. For the serve upon the respondents, serve upon the respondents regarding the restoration of the appeal, except respondent number 1. Full stop. Let the matter appear in the list on February 21st under the heading of to be mentioned. Under the heading, no, to be mentioned in the appeal. To be mentioned. ठीक है.
My lord,
Yes.
one indulgence. That 1 week can be made it to 2 weeks.
No.
Grateful.
Grateful, madam.
Only some cost have to be deposited and you are saying 2 weeks. Why?
Madam, I will do the needful, lordship,
Yes.
as per your lordship direction. Much obliged, lordship.
Next.
Item number 6.
What is this?
This matters, my lord. There's two affidavits already filed. My lord's records also is there. One report and one supplementary affidavit. My lord, due to miscommunication of this, I have not handed over the supplementary affidavit to other sides. And my lord, if my liberty is given to the hand over this copy of
Supplementary affidavit?
already in
They have
my
filed-
lord's records.
They have filed
We
supplementary
filed
affidavit?
pursuant to the my lord's direction. We filed the supplementary.
You filed the
affidavit,
supplementary
Lord, sir.
affidavit.
And that was previously there's a report, and pursuant to the my lord's desire, my lord, we filed a supplementary affidavit annexing the reports of the both the petitioners and the selected
Supplementary
candidates.
affidavit,
Yeah.
yes.
Yes, my
I have the supplementary affidavit
But the problem
as
is
well as the report.
yes, the problem is this:
Not served.
the copy of the supplementary has not yet
No.
served, madam.
Has not been.
You don't have the copy?
Lordship, that's the problem. I can deal with my lords. I have not been copy, but if my lords have I have a chance to take back and then xerox and hand it over. Keep it on day after. My lord, I'll come, my lord. That will problem, my lord.
Take necessary steps what you can. Okay. Now
Lordship,
next.
lordship.
Not this week.
Grateful, madam.
Great.
Number 7.
I'm for the petition for my lord.
Yes.
Extension of interim order, lordship. Lordship, 3rd December, lordship. Your lordship was directed to extend the interim order till 7th January 2025.
Yes.
Lordship, I mentioned before Honorable Justice Rai Chattopadhyay on the determination on that day. Your lordship are not sitting. And again, then 10th January, I mentioned before your lordship.
Mr. Sirsan Bandyopadhyay and Ritesh Kumar Ganguly.
Given notice? No? Sorry, excuse me.
Report has to be submitted by the state. No report. Okay.
This was not in my.
I extend in the time for filing
Yes, my
report.
lord.
Okay. Please take down. This matter appears under the heading of extension of interim order. Learned counsel appearing on behalf of the petitioner submits that the interim order passed by this court on 3rd of December 2024 was extended till 7th of January. He further submits that the state was directed to file a report in the form of affidavit. No report has been placed by the state, so he prayed for necessary order for extension of interim order. Learned counsel appearing on behalf of the state seeks accommodation of some time for filing a report. Also, considering the submissions of all concerned, the interim order passed by this court on the earlier occasion is further extended till February 11th or until further order, whichever is earlier. Full stop. Let the matter appear in the list on 11th of February under the same heading. Full stop. The state authority is at leave to file the report within the adjourned date.
My lord. My lord. Grateful, my lord. Grateful.
Next.
But the petitioner, my lord, this matter was extensively heard by your lord, and direction was passed for application and reply. Number and your lord was further pleased to pass an interim order. Number lastly, on 24th December 2024, this matter was taken up by my lady Justice Rai Chattopadhyay.
Yes.
And my lord, her ladyship pleased to extend the interim order till 31st of March with the further direction. Let the matter be placed before your lord. Number I pray before your lordship kindly fixed any date subject to your lordship convenience and my learned friends convenience, and lordship kindly dispose of the case. There is a short point involved in this matter. Pleadings are complete.
So why today it is appearing?
My lord, it has been mentioned, it has come up my instance, my lord,
Yes.
because the matter was fairly at the top of the hearing list, my lord. Certainly, my lord, it was not appearing in the January list. So, my lord, let a date be fixed because the matter is otherwise ready for hearing.
Was it heard by me?
My lord.
Your lordship was
My
first
lord.
time.
And in fact, my lord directed this matter to appear fairly on top of the hearing list, my lord.
What is the matter?
2024, your lordship pleased to pass an order of opposition and reply and also pass an interim order.
Okay. I understand. So when can we hear?
But next week, any date, subject to your lordship convenience.
Vishwanath. 28, second half. Okay. 28.
Grateful.
2 p.m.
2 p.m.
Okay.
March of.
Let the matter appear in the list on 28th of January 2025 at 2 p.m. for hearing.
March of. Yes.
Next. Pass it over. Next.
Lord, item number 10, I beg to appear for the
10, my lord, appearing
Lordship, I am praying for a short passover, Lordship. Learned advocate, Mr.
You are
Kotesh,
appearing on behalf of
for the
Mr. Mukherjee. Okay.
For the petition. Also, kindly consider the last date order passed by this court.
Yes, where is the affidavit?
Lordship, I have a candid view. Lordship, I send it to the affidavit, the department, my lord. My lord.
Affidavit is ready.
Lordship, ready and for affirmation, I'll send it to the department, my lord, because the recent days, my lord, the officials of the department is so busy because the CM's visit is Murshidabad, my lord. But you kindly give some more time, my lord.
The
1 week time.
Murshidabad issue has already been passed.
Lordship,
Now it is
Lordship,
solved.
today I am praying, Lordship, my interim order has been refused. That Lordship, His Lordship, please to observe that let the affidavit filed, then question of interim order will be considered. But Lordship, they are deliberately failed to file affidavit in
There is
opposition.
no question of delivery.
Lordship, let there be a stay of the impugned order of Lordship, the dismissal.
Lordship, there isn't they avails two forum, my lord. First appellate forums and also second, and they came against this. The final
That is
order
the
of second
procedure.
order.
What
My lord,
procedure we have?
my lord, Lordship, kindly give some more days, 10 days, 7 days time, my lord. I come with an affidavit, my lord. We already sent it, my lord. I have candid to my lords. Much prior because of this. Keep 7 days time, my lord, as a peremptory. Keep it on peremptory.
No, they have annexed the order of both the authorities.
Yes, yes.
First appellate authority
Yes,
and
yes.
second appellate authority. As well as the
Entire matters is my lord's.
So you can proceed with the matter for hearing.
Because lordship direction, my lord, there is an order of affidavit, my lord. Lordship, kindly bear me 7 days time, my lord. I'll come and file an affidavit.
They are roaming day by day.
Lordship, it is very innocuous. Also, I am apologize for this, my lord. I'll give 7 days time, my lord. I'll come. If it on Tuesday or Thursday, lordship, I'll come. In the meantime, I'll exchange
No,
it.
it will be Monday. Come on Monday. Positively Monday, otherwise the matter would be hard
Lordship.
on merit. Please take down. Mr. Honorable Judge, Learned Counsel appearing on behalf of the state authority that the affidavit as directed to be produced by this court, as directed to be submitted by this court is not ready. Prepared for necessary accommodation. It appears that the petitioner has challenged the order of the concerned authority regarding his termination of license. Full stop. All the orders of the authority were annexed with the writ petition. Full stop. It appears that the matter can be heard on the basis of the documents filed by the petitioner. However, the state respondent that it has leave to file the affidavit within a week. Let the matter appear in the within a week positive. Let the matter appear in the list on 27th of January under the same heading. If the report on the form of affidavit as required by this court was not filed by the state on the adjourned date, the matter shall be heard on merit. Full stop. Next para. Affidavit of service filed on behalf of the petitioner is taken on. Okay, 27th.
Lordship, grateful, man.
Thank you.
Sit down.
In item number 11, Lordship, I beg to appear on behalf of the petitioner. Lordship, there was an interim order regarding the vacancy notification, Lordship. And subsequently, Lordship, they have filed the opposition. And as the several matter is pending before the division being Lordship, being matter number 1543 of 2024, Lordship, we are abide by the same Lordship. So kindly Lordship may direct the matter to go out of list, and when the order will be passed, Lordship, then Lordship decide on
This is
merit.
not the same matter, Your Lordship.
Have you filed any report?
No, Your Lordship, this is not a same order, Your Lordship. There was no direction for a report in any event. Your Lordship, the petitioners.
No order is there regarding.
Oh, there is no order, Lordship.
There is
In
no
this
order.
matter, Lordship, there is no order.
Your Lordship, the petitioner's license had already expired, Your Lordship. There is no existing license in the name of the petitioner, Your Lordship. Therefore, the regular matters and his case is absolutely different.
So what is your case?
Lordship, so far the in my instruction is concerned, Lordship, I will withdraw this matter, Lordship, but I have to take 1 day's instruction, Lordship.
Lordship, then after I will,
His license
yes, your
expired
Lordship.
31st 12 2023, your lordship.
In earlier occasion, the matter was taken up by the coordinate bank, Lordship. So my humble request before your Lordship that give me 1 day accommodation, Lordship. Tomorrow I will come with the instruction with the letter from my client and I will withdraw the matter, Lordship.
Your lordship, on the last occasion also the same
Yes, your
submissions were
Lordship. Yes, sir. But
made
I
before
may
the
not.
other bench.
Yes, your
where
Lordship.
he sought time for taking instructions and
Only 1 day accommodation, Lordship.
same submission is being made.
Do you
after
have
the-
any copy of the order that his license was terminated?
Yes, your lordship. I have written instructions, your lordship.
Okay, keep it
Upon the-
yourself. Keep it yourself. Tomorrow I shall.
Tomorrow, Lordship.
Yes, sir.
Okay.
Get food, your Lordship.
Not today. You keep it yourself. Hand it over tomorrow. Next.
In item number 12, Lordship, I beg to appear on behalf of the petitioner, Lordship. Lordship, the petitioner has applied for the new license issued by the in subject to the vacancy declared by the West Bengal Food Safety Department, Lordship. The petitioner has applied for the license. Your Lordship will find from page number 34 that the government of West Bengal Food and Supply Department acknowledged the application by the petitioner. And subsequently, Lordship, one inspection has been conducted by the respondent authority, Lordship. Your Lordship will find for page number annexure P2, that is in page number 38, Lordship. That the
page number 38.
38, Lordship. That the Syed Islam is the applicant. That the inspection will be conducted on 11th June 2024 at 11:30, and then the inspection has been conducted. Now, your Lordship, kindly come to the representation which has been made by the petitioner. Subsequently, when the inspection has been conducted, Lordship will find it transpired from the page number annexure P2, page number 38, Lordship, that the 11th June was the date when the inspection has been conducted. And after on 11th June, Lordship, come for, if your Lordship come to page number 38, your Lordship will find.
Item number, what is that?
This is item number 12, Lordship.
23583.
23583.
235.
Lordship, that is Sonali Das.
Sonali Das.
Sonali Das, Lordship. 12 number. Page number 43, Lordship. Page number 43. That is annexure P3, Lordship.
43.
Lordship. Where it has been stated, Lordship, that the
will be conducted on
13th December 2023. And the same has been conducted, Lordship. Now, what is the reason decision has been cited by them, Lordship? That no decision has been cited. Subsequently, the application of the petitioner has been rejected. The petitioner has also made a representation to the concerned authority, Lordship. That is in page number 46, Lordship, annexure P5. That আমি শ্রীমতী সোনালী দাস আমি অমুক অমুক এদের জন্য আবেদন করেছিলাম আমার অ্যাপ্লিকেশন নাম্বার সাচ এন্ড সাচ বর্তমানে অ্যাপ্লিকেশন স্ট্যাটাস দেখতে পাচ্ছি যে আমার আবেদন প্রত্যাখ্যান করা হয়েছে নাও দে হ্যাভ উইদাউট সাইটিং এনি রিজন লর্ডশিপ দে হ্যাভ রিজেক্টেড মাই অ্যাপ্লিকেশন and I made the representation to them, Lordship, that has been,
that your application has rejected.
Lordship, it will transfer from the online portal.
Where is the copy of portal?
But Lordship, that's I have not annexed, Lordship, but after that, Lordship, we made the representation when it has been transferred, and subsequently that was not also reflected, Lordship. In earlier occasion, Lordship, that the one person is claiming to be the
Sonali Das rejected.
Page number 42, that is his FPS application was rejected, not his consideration was rejected.
No.
FPS
That
application was rejected.
That has been mentioned in the representation. That has been mentioned. That has been rejected. The online application has been rejected after conducting the inspection. Now, my contention is very simple that when he has rejected my application, they must citing any reason for which they have rejected my application.
There is no scope in the portal to cite any reason.
Yes, your Lordship. Then they must communicate me that for which ground they have been rejected. But that has not been cited, Lordship. We made the representation, Lordship, and subsequently no answer has been given to us, Lordship. The state is the answering respondent, Lordship.
He is eligible.
Because date, my lord, I have no, really speaking, my lord, to be honest, my lord, to be candid, my lord, I have no instruction as on date.
Then I direct the authority to dispose of. What is your stand?
My lord, I have received a petition today itself. My learned friend has served it today.
You are the private respondent.
I am the private respondent. I got the
license.
I got the license. My license was awarded in favor of me 2 months back. I have successfully run the go down for 2 to 3 months now. My lord, I have already filed two counters also. I have filed, my lord. So my lord,
Pursuant to vacancy declaration and all. So, to be candid, it has cause of action does not survive.
cause
now.
of action doesn't survive, my lord. Because I have already done successfully run my go down.
When my application has been rejected, I come before your lordship, I file this writ application. During pendency of this writ application, whatever step has been taken, lordship, I cannot say on that, lordship. My only contention is that, lordship, ask them to give a report before the honorable court why my application has been rejected, and if there is a sufficient ground,
required. You go to the authority will take the decision.
lordship, maybe directed to the authority for the consideration.
Authority will consider your representation.
Absolutely.
My lord.
If it's possible, lordship, and if he is also
Records the subject that private has already
appointed.
Appointed, and my lord, 2-3 months I have run the shop, my lord.
Running the business.
And kindly, my lord, record my submission that the cause of action does not survive after the vacancy has been filled up.
Okay.
And my lord, another thing is that as far as my instruction goes, the petitioners, the petitioners go down is not according to the standards.
How he came to know, lordship? How he can answer, lordship? No, you can't. That's inspection conducted by the state authority. He's a private responsibility. He have everything. He have all knowledge about why my application has been rejected. Authority is not answering on that
You are
point.
residing in the same locality.
No, he's not residing at the same locality, lordship. Now that is my that is my writ application, lordship. Why the favoritism has been placed in favor of him, lordship?
No, you have not disclosed anything regarding favorism or anything.
No, I am not in a position to disclose it, lordship. As because of the rejection, I do not know why my application has been rejected. If they will cite if he cite any reason that the ground for which my application has been rejected, lordship, I come with some point, lordship. But unless there is no provision, they are not providing us with this document that for which that ground you have been rejected, and a fresh option has been given that you may fulfill the deficiency if at all arises. That has not been taken place, lordship.
In normal courts, your lordship is passing orders in vacancy declaration matters subject to the pending appeal. But here, my lord,
here no issue. Here
no, it's not the similar issue, lordship. Merely stipulated the time for consideration, lordship.
Okay, please take down. Present petitioner applied for the license of FPS dealership in pursuance to the notification of the SCFS Kandi, Food and Supply Department, Government to West Bengal. Notification dated for notification dated 25/8/2023. Issued by the SCFS Kandi. SCFS Kandi, Department of Food and Supply, Government of West Bengal. In respect of the location for the vacancy, Kandara, Daspara, near Kali Mandir. Kandara, Kandra, Kandara, Daspara, near Kali Mandir. Full stop. It is the case of the petitioner that in pursuance to his application, the concerned authority has issued a notice for inspection at the proposed shop cum go down of the petitioner on 13th of December 2023.
may I take your lordship kindly?
Yes, on the same date, the inspection was conducted. However, the petitioner came to know from the online portal that his candidature was rejected. He submitted an application, submitted a representation with the authority on 27th of August 2024, requiring the reason for rejection of his application. The authority concerned has not responded. Hence, he again applied, he again submitted another representation on 2nd of September 2024. Full stop. None of his representation was considered. Hence, he approached before this court. Full stop. Respondent number 6 appears before this court and submits that in pursuance to the said notification, respondent number 6 applied for the vacancy and he was appointed by the concerned authority. Full stop. Since 2 months, he is running the business after receiving the license. Full stop. Now, after the license has been commissioned in favor of respondent number 6, the present petitioner has no cause of action. Full stop. Mr. Dotto, learned counsel, appearing on behalf of the state authority, submit that the present petitioner candidature must have turned down due to her ineligibility. However, Mr. Dotto is candid to the fact that no report has received, no instruction has been received from the concerned authority. Having heard the learned counsel for the party, it appears to me that the petitioner has not stated anything adverse against the act and action of the state authority. However, the state authority must have considered the representations of the petitioner. Under the above observation, the incident date petition is disposed of, directing the petitioner to approach the state authority. No, cut off. Disposed of with a direction to the concerned SCFS, being respondent number 5. Respondent number 5.
May I point out just one thing? There is no representation to the SCFS. Both
Only
of the representation are to the DDFS.
Okay. So you have to file a fresh.
My lord, DDFS, what will DDFS do? DDFS is the allotting authority, my lord.
We will make a fresh representation to the
SCFS. Yes.
SCFS, my lord.
The read petition is disposed of with a direction to the petitioner to approach the concerned SCFS, being respondent number 4 of this matter, respondent 5 of this read petition, with a specific application coupled with the copy of this order.
My lord, kindly make it clear specific representation, because the application is otherwise, my lord, it can constitute other. Kindly make it clear specific representation.
Yes, representation. I have said representations. কি বললাম? Application বলেছি। Representation বলেছি। With a couple of the copy of this order, so that his required information may be forwarded to the petitioner, or required information may be forwarded to the petitioner within a specific time. The SCFS concerned shall dispose of the representation of the petitioner within 6 weeks from the date of receiving of such representation from the petitioner. In disposing of the on disposing of the representation, the respondent number 5 shall give the sufficient opportunity of hearing to the petitioner. Sufficient opportunity of hearing to the petition.
Well, and me, my lord, because I am also.
You also want to repair there. What is your
in any case, SCFS decides against me, my lord, then
there would be otherwise. You are running the license. Why?
I am running the license, but still, my lord, kindly gives me a hearing, my lord. In any case, SCFS decides against me, my lord.
Very well. You are party of this matter. So
My lord.
benefited party.
Giving shall to the petitioner as well as the private respondent number 6, and shall dispose of the matter within 6 weeks. Full stop. The region decision shall be informed to the parties within 2 weeks thereafter. Another petition is disposed.
Obliged.
Next.
And for the petitioner, Lordship, kindly make it adjourned for the day because senior counsel in Supreme Court today.
Your Lordship, if it is not today, kindly keeps it any day next week. Tomorrow I won't be available for personal
Okay,
difficulty.
not this week. Next.
I am for the petitioner, my lord. Small thing, this will not appearing, but thinking not to be, my lord. Normally he's there, but the same.
But what happened is that on the last occasion, your lordship
I am
was
not
pleased
briefed in
to.
the matter. That is why.
Actually, what happened on the last occasion, your lordship was pleased to direct my learned senior friend to take instruction whether any vacancy has been declared or any approval has been accorded. I made an application pursuant to the vacancy declaration notice dated, my lord, 27/12/2022. I have been recommended by the inspecting person. What happened thereafter? Nothing has been done. I made a reply. In the reply, initially intimation has been given that all the application is under process, and another reply in response to an RT application, another response has been came that there is a chance to declare re-notification. That's why I have challenged, and I came to know that my rejection was.
Okay, come on tomorrow. I understand. I understand the issue.
Only thing is that
Senupto said that he shall come with the proper instruction.
whether vacancy has been.
Stand over for the day, that's all.
Come on tomorrow. Okay.
In the meantime, actually,
Not today. Pass it over.
And for the respondents, my
Not
lord.
today. And for the petitioner.
That event, my lord, day after tomorrow, my lord, since I have also asked for instruction, my lord, some queries are there regarding. So
Not this week. No, what are you saying, Mr. Chapu?
day after tomorrow would suffice, my lord. I have raised
I
some
don't know
queries.
whether scenario will come or not. Come on next week, okay?
Not this week.
No, not today only because senior is in a Supreme Court today. That is why.
Oh, then next
He
week,
will
my
come
lord.
back
Not this week.
tomorrow.
Next. Pass it over. Next.
I appear on here.
I appear on behalf of the state, Your Lordship.
Not pursuant to a vacancy declared by the subdivisional officer, petitioner before your lordship, along with other aspirant candidates, participated in the process. Applied for the.
Yes.
My lord, thereafter, on 2nd December, it came to the notice through online portal that the case of the petitioner has been rejected. On 3rd, petitioner made the respondent number 5, the subdivisional officer, in order to ascertain him what are the reasons behind for cancelling his participation. My lord, that was not entertained. My lord, immediately on 3rd December, he made a complaint to the authority with certain things which appears at which I have pleaded in my writ petition at page 6. What are the grounds? According to the petitioner, he is in a better footing. What are the grounds? My lord, kindly turns to page 6 of my writ petition, paragraph 10.
Whether anyone appointed?
Yes, Your Lordship. Your Lordship, Shumon.
Definitely that thereafter, after getting my, because on 30th November, it was uploaded in the portal. 2nd, it came to my notice. On 3rd, I made the authority and made a complaint through my learned advocate. Definitely thereafter.
Your Lordship, may I make this submission, Your Lordship?
Let him complete, please.
Paragraph 10.
Paragraph?
Paragraph 10. 4 reasons I have cited.
Yes.
Because the present declaration, vacancy declaration has been made from deducting certain quantum of ration card holder from the existing Emmer dealers who happens to be the uncle of the respondent number 8. And other reasons, paragraph 7, Roman 2, Roman 3, and Roman 4. But page 23, 22, my lord, 22 onwards. written representation through learned advocate on 5th December 2024,
Page,
page 22.
page 22. Yes,
22
this is a representation.
Through learned, and not a representation, it's a through learned advocate.
Letter
My
to learned advocate.
Yes, my lord. Even if the license has been granted in favor of the private respondent, that has been, in my understanding, that is after fee.
Your Lordship, all such submissions are presumptive, Your Lordship, and in anticipation, Your Lordship. According to the field report, Your Lordship, the petitioner herein did not even comply with the requirements of the notification, Your Lordship. Your Lordship, the petitioner, after field inquiry, it was found that the measurement of this shop of the petitioner was only 92 square feet, whereas that of the private respondent who has been granted the license is 210. Your Lordship, whereas the shade over the godown was temporary in case of the petitioner.
Come with the report then.
I shall file a report. All the documents are there, Your Lordship. The petitioner had scored mainly 53 out of
Okay,
75.
you come with the report, let the direction be there.
Yes, Your
You
Lordship.
come with the report, you see the report, they have filed.
My lord.
Okay, thereafter you can file the reply.
May I make one additional prayer? Because at the very outset, my lord, I have stated that the selected person is close to the one Muntu
Absolutely vague, Your Lordship.
Everything
That is
they
no
will,
ground.
they will play the, submit the
Well,
report
the
on respect of
guidelines is-
everything.
My lord.
And respect
Let
of
them
every,
deal with my
respect of the writ petition.
Writ petition, my lord.
Yes,
I bow down to your lordship.
yes. Please take down. Having heard the learned counsel for the parties, it appears to me that the instant writ petition cannot be disposed of without awarding an opportunity to the state respondent to file a report in the form of affidavit. Accordingly, the state is directed to submit a report in the form of affidavit in respect of the FPS vacancy, impugned FPS vacancy, and the appointment of the private respondent, as well as the queries raised in the writ petitions. Let the report be filed within 4 weeks. Within 4 weeks from date. Reply, if any, within 2 weeks thereafter. Let the matter appear in the list on 2, 4. March 3rd. 3rd of March. Another same heading. Affidavit of service filed on behalf of the petition is taken. Next.
In item number 19, lordship, I beg to appear on behalf of the petitioner, lordship.
Where was it?
The petitioner has applied in a new vacancy, lordship, for the declaration of the license in favor of the petitioner, lordship. The application is, lordship, if your lordship come to page number 34, lordship, that the acknowledgement supplied by the government of West Bengal Food and Supply Department that petitioner has applied in the block of Barwan subdivision, Kandi district, Murshidabad, for the issue of license for FPS dealer, being the application number such and such, lordship. That application has been made on 15th of April 2024. If your lordship come to the page number 38, your lordship will find that is the annexure P2, lordship, that the inspection notice has been allotted and in favor of the petitioner, lordship, where it has been specifically stated that the inspection will be conducted on 11th June 2024. And on that day, lordship, inspection has been conducted. So, lordship, that the vacancy upon which the petitioner has applied, lordship, that is the application made on the 15th April 2024. And on June, lordship, the inspection has been conducted by the competent authority. Now, lordship, what happened during this pendency of this inspection, lordship, they have not been given with any answer to the inspection, where the inspection has been come towards its lordship, its result or not. The petitioner has made a representation before the concerned authority on the 17th of September 2024. Lordship will find from page number 41, that is annexure P4. that where the petitioner has stated before the subdivisional controller and the district controller that the expedite the issuance of new FPS license under the vacancy issued by the that is page 41, Lordship. That the petitioner made a representation to the concerned SDCF and also the district controller of food and safety Murshidabad, Lordship, by stating that, Lordship, to expedite the issuance of license. As the inspection has been conducted and nothing remains, Lordship, they have to give the result, what is the outcome of the inspection report, Lordship. Now, during this pendency of this application, Lordship, that subsequently, Lordship, there is one notification has been issued in the portal, Lordship, that is in page 44. Lordship will find from page number 44, Lordship, that the application of the petitioner has been rejected, that the application date was 14/4/2024, and it's subsequently been rejected, Lordship, but without citing any reason for which the application has been rejected. Now, then after, Lordship, that the no. Yes, Your Lordship, I have served upon the state respondent. In earlier occasion, Lordship, the matter was appeared before the coordinate bench. As this court was lies vacant, Lordship, then they have come before the court and, Lordship, they ask for the time and come with the report, Lordship. I do not know, Lordship, whether there is any order or not, Lordship.
No, nothing order is there.
Lordship.
No order is there.
Because then, Lordship, this matter come before the regular bench, Lordship. Now, what is my initial peer before Your Lordship, that no steps should be taken as per this vacancy notification, Lordship? Lordship, so far my instruction is concerned, Lordship.
Rajat Datta was
yes,
appearing.
Rajat Datta is appearing, Lordship. Item number 19.
But I'll inform Mr. Datta. Kindly.
So my
what is your prayer?
My initial prayer is, Lordship, that they have to cite that what is the reason for it, Lordship, for the rejection, and during pendency of the writ application, Lordship, no license to be given to the other beneficiaries, Lordship. So far my instruction is concerned, Lordship, they have not selected anyone, Lordship. I have prayed in my prayer A and B, Lordship. Your Lordship will find that during this pendency of the writ application, Lordship, that no one should be given with the license until and unless my Lordship, that my application has been disposed of, Lordship. That what is the reason for the rejection, and if it possible, Lordship, I may rectify if there is any deficiency for the rejection, Lordship. If it possible, if the law permits, Lordship, then if the state come with the report, Lordship, only then can I submit, Lordship. That during this time, Lordship, may be
So
protected.
you know there is some deficiency.
If it has been rejected, Lordship, there must be some deficiency has been pointed out. Otherwise, it will not be rejected, Lordship.
The deficiency cannot be cured.
But Lordship, if the reason which has been cited is not at all a deficiency, Lordship, then it can be cured, Lordship. Yes.
If there is no deficiency,
Yes, Your Lordship. As it has been popped up in the official website that your application has been rejected, but without citing any reason, Lordship, it is very difficult to ascertain that what is the ground for rejection, Lordship. Then I will inform Mr. Rajat Datta and come
yes,
by
you
tomorrow,
inform
Lordship.
Mr. Datta, come tomorrow.
Lordship, make it not today only, Lordship.
Yes.
Let it remain in the position, Lordship. Let the matter be remain in its position. Grateful to you.
Not today.
Lord, item 20, before my learned friend would start, my Lord, Mr. Sengupta is appearing, my Lord, his matter is going on. Lord, kindly makes it not today, my Lord, similar prayer.
Yes, which for the petitioner?
I am a pre-petitioner.
What is the matter?
My Lord, matter, my Lord, I am challenging the notice. My Lord, kindly, my Lord, turn page. My Lord, petitioner ke father, the on Bhamad Dotto, the diet ke 1993.
93.
93. And ke thereafter ke after my Lord dead, my Lord, he is the unmarried. My Lord, he had the no issues, and he take the adoption to the petitioner. My Lord, the parts of the adoption, but he's made an application, and on the
When he made
application immediately and 1994, the license, the MR dealership license was granted. And after the 30 years,
yes,
after 30 years, the respondent authorities issued a notice. The only, my Lord, the explanation notice, and without disclosing anything on what is the main subject matter, that you are not the adopted, the one the learned code below, without disclosing the number of this title suit or anything. Only, my Lord, order date, and the God bless declared adoption is the void, and you explain without supplying a document. And immediately, my lord, I have to search out the which order was passed in the year. The order was passed in 2010. After, my lord, 14 years, this notice was issued. Kindly, my lord, turn, my lord, page 23.
Very well, come on tomorrow.
Very good.
Matter is there to be heard,
My lord.
not today.
Grateful.
My lord. Yeah.
Yes, I am for the state respondent led by Mr. Rajat Dotto. He is today absent. He is present in another court. Kindly not today, Your Lordship. This is the first time. Kindly, the report is necessary. But some.
What is the matter?
The matter is with regard to that, my father was a fair price shop owner.
Okay.
After his death, I have been granted fair price shop license. During the period when my father was dead and I was granted the license, during this period, my entire ration card was temporarily detagged from my father and tagged with the nearby dealer. And he was running the fair price shop. After I have been appointed as a fair price shop dealer, I have been granted with new EPOS machine with new ID. And what happened, my lord, I have been allowed to distribute ration articles with the old ID, with the ID of the with whom I have my father's ration card was tagged. Allotment was made on that. In the meantime, what happened? From the very beginning, since they have allotted lesser quantity of ration articles in my favor. Thereafter, my lord, what happened? I have seen in the EPOS machine, they are showing the entire balance, and actually they have delivered in lesser quantity. I made a representation to that effect, and after making the representation, what happened? They have deducted the entire quality. I could not able to run my business.
Deducted the entire
quantity of ration articles, and I could not able to run my this. I could not able to distribute the ration articles. Each and every month, they are deducting each item 20%.
What is the reason behind it?
There is a positive stock. They are showing the positive stock in the EPOS since they have conjoining the balance of my father as well as the ration card with whom my father's dealer ration cards was tagged.
I understand.
They are total. They are adding both the allotment. They are after deducting the same from my.
So what you want now?
Let them take instruction tomorrow. In that event tomorrow, since every month they are deducted. I could not able to run my distributor dealership business. Let the matter come tomorrow. I have no problem if they are taken up tomorrow.
No, if you want any interim order, then
I want an interim order, not to take and not to deduct any. Let them file report.
okay, then come on tomorrow.
Definitely, I'm praying for an interim order. I have made a specific prayer to that effect, not to deduct any ration article, 20% article. Prayer, my lord. Prayer, if and G.
Have you got the matter?
Got the matter, but report has not till date not come.
No, they want an interim order.
Prayer, F and G, my prayer.
Deducting a quantum of ration articles, he is wanting
Not to deduct any quantum of ration article till the disposal of the matter.
My lord, I have no problem.
What is your instruction?
without report? Very difficult.
Yours will find kindly come to page 26 months. Yours will get
then
it.
you take instruction, come on tomorrow then.
Grateful.
Okay. Let them come tomorrow. They have he is not ready with instruction. You come with instruction tomorrow, okay?
Grateful, Lordship.
Yes. Next. Keep it.
22, my lord, I am for the stay.
Lordship, 22, I'm for the petition, Lordship. In this matter, Lordship, Mr. Pritam Chaudhary is appearing. He's leaving on another court, Lordship. Kindly make it possible or not today, Lordship.
Not today.
Not today. I'm grateful, Lordship.
23, I am for the petitioner, my lord. In this matter, Mr. Suman Sengupta is on his legs in courtroom number 1.
What is the matter?
Matter, my lord, regarding the new vacancy, my lord, created in the area where the petitioner has been functioning. While affidavit of service appearing for the state. Where, my lord, the notification that is annexed, my lord, at page, my lord, 15, serial number 8.
I said P4.
A similar order has been passed by your lordship in the identical case of the area in question. Serial number 8, page number 15, annexer P4.
Memo number?
Memo number 260, dated 29th May 2024, serial number 8, page number 15.
Where is your license?
My license is at, my lord, page number 14, P3. And he has, my lord, distributing within the adjacent areas, my lord, including the area in question where the new vacancy is created by, going to be. And paragraph 5, I have stated, my lord, serial number, my lord.
What is page 13?
Page 13, my lord, that was the initially, it was in the name of the mother. Subsequently, it has been transferred to the, my lord, petitioner.
Sir.
From Kumari Mondal. That's why the petitioner has been given the license afresh, my lord. So he has come before your lordship assailing the, my lord, vacancy. Of the said block, your lordship has been pleased in other cases.
Okay. Please take down. Same order they will find. State authority to file affidavit in opposition within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Considering the fact and circumstances of this case, the state authority is at leave to proceed with the selection process. But so far as the appointment, appointment of the impugned dealership is concerned, the same shall not be commissioned in favor of any person till the disposal of the batch of appeals pending before the learned division bench of the court, being MAT 1543 of 2020. Let the matter go out of the list, particularly liberty to mention. Affidavit of service filed on behalf of the prisoner is taken under court.
24, my lord, same block, page number 16, my lord, the vacancy notification, my lord, memo number 146, dated, my lord, 3rd March 2023, page number 16.
Though, my lord, I am
License
controverting
is
this, but
at
there is no challenge of
License is at
2013
14.
control orders, my lord. There is no averment on the part of the petitioners. The challenging of 2013 control order. There is no pleading at all, my lord.
Pleading 5?
5, paragraph
5 is there.
No,
License
there is
is
no,
at page, my lord, 14.
my lord, there's no
Page
specific
16,
averments.
paragraph 6.
Only the
Paragraph
petitioner is
6,
a
paragraph
rational
6.
such curtailment. There's regarding the curtailment, and my lord, there's no challenge of 2013
From
control
the
orders.
units which have
Though
been
I am not
enjoyed by the
rigid
petitioner,
regarding the
that will
pleadings
be
is concerned,
cutted.
my lord.
That's why the
Lionel
problem
senior
is
been
there.
so cautious about
And that's why your lordship has
get the
been
files
placed
in
in
the
identical
petitions.
cases
There's
in the past
I was
You have only stating the grounds, not the pleadings.
Lordship,
Grounds are there,
I am
think.
not rigid to these matters also, but my landed senior was sincere about these pleadings regarding
The matter.
2013
My
control
lord,
orders.
page number,
Regarding challenging the 13 control order.
my
Not
lord,
like that.
my lord, paragraph, my lord, 5, page 4.
What is
You are
saying
not
the paragraph?
specific on that point. You are not specific on that point. On the
I am
point
not taking any plea. I am not
learned
taking any
division bench.
advantage of this, but
Very well. Where is the license?
License is at page, my lord, 14, P2.
Page 14.
P2.
Similar direction.
Grateful, my lord.
Shishanu Bandyopadhyay and Mr. Ritesh Ganguly, my lord, are appearing in this matter on behalf.
Yes.
The 25 appear for the petitioner, my lord. May I file the affidavit of service, my lord?
What is the matter?
Yes, my lord. In the writ petition, my lord, I have challenged, my lord, the license which has been issued, my lord, in favor of the respondent number 6, my lord, on various grounds. But, my lord, today, my lord, I will be urging only one ground. Why? The reason being, my lord, that the state is required to file an affidavit and your lordship put here. The reason why I'll be urging one ground only, my lord, because in this matter, my lord, I will be praying for an order, my lord, of stay. Lord, lordship knows, my lord, whenever I'm challenging, my lord, very rarely, my lord, do I ask for a stay because I don't want to disturb the system. But in this case, my lord, the facts are such that, my lord, lordship will, my lord, in fact, my lord, I will not say, my lord, there is any mistake on the part of the state because the state has been, my lord, a fraud has been played upon the state. An incorrect affidavit, my lord, has been filed by the respondent number 6. Why do I say so, my lord? The respondent number 6, my lord, the only ground that I say, my lord, is a member or was a member of the Panchayat Samiti, my lord, at the time of making of the application, my lord. For that, my lord, I had, my lord, if your lordship comes to page 20, I'm sorry, my lord, paragraphs 8 and 9. Paragraphs 8 and 9, my lord, lordship will find at page 5. There are various grounds, my lord. I am not urging those grounds, only ground E and F of paragraph 9. E and F. The respondent number 6 was a member of Panchayat Samiti at the time of application. F. The respondent number 6 has made false statement in the affidavit furnished in terms of the subject notification. But why do I say this? Because, my lord, the affidavit, my lord, there is a, my lord, specific provision, my lord, where you have to state whether you're a member or not. My sample, your lordship will find at page 21. This is my affidavit, my lord, which, my lord, lordship can take it as a sample affidavit. Page 21, my lord, paragraph 4. That I am not a member of local bodies, local authority, Panchayati Raj institution, board, member of legislature, or a member of parliament, my lord. So there has to be a specific averment in this regard. Now, my lord, the fact that he was a member, my lord, I did not have the copies then, my lord. Thereafter, my lord, after getting the copies, my lord, I asked, my lord, my learned, my lord, advocate record, my lord, to get a supplementary affidavit affirmed, my lord. Even if your lordship comes to page 4. This is, my lord, from the website of West Bengal State Election Commission. And your lordship, if your lordship turns over to page 7. Page 7. Page 7 under, my lord, Nizampur 2 PS 22. Lordship has seen that?
Nizampur 2 PS 22.
22. The first name, Muhammad Anwar Ali. Male, the number, my lord, lordship sees, my lord, the total number of votes that he had obtained, 1320. An admitted fact, my lord, because I am also, my lord, a resident of the same village, my lord. He, my lord, was successful in securing his membership, my lord, as a member of, my lord, the Panchayat Samiti. And, my lord, so far as this clause in the notification is concerned, lordship will kindly come to page 17. And this is not a ground, my lord, which can subsequently be, my lord, corrected. Page 7, page 18, if your lordship turns over, my lord, part 3.
Page
18 is part 3. This is a part of the notification, my lord. Part 3, if your lordship comes to page 18. The typed copy is at page 18A. And lordship knows, my lord. By now, lordship knows, my lord. It says, my lord, following persons, entity shall not be eligible to apply for a license.
Yes.
So this is not a case, my lord, where, okay, application can be done. And like, my lord, in case of conversions, that later on you can rectify the, my lord, the mistake. But here, my lord, you cannot even apply if you are a member. And this, my lord, notification is of 16th November 2022. 16th November 2022. Whereas he had become a member of the Panchayat Samiti, my lord.
What is the last date of application?
Normally, my lord, it is always 45 days, my lord, from the date of
publication.
Date of
Publication in the
publication.
indicative advertisement.
21 days from the date of publication.
21 days.
What is the date of publication?
16th November 2022.
No, it is 13th of January 2023. Date of publication of indicative advertisement is 13th of January. Date of notification is 16th November 2022, my lord.
Date of publication is
13th of January 2023.
13th of January 2023. When the election was held? Panchayat general election 2018.
2018. I understand it is not for the state, my lord, to argue on behalf of the respondent number 6, my lord. I understand that.
Have you served upon the respondent number 6?
I have filed the affidavit of service, my lord. But this is, my lord, something that I'm stating on affidavit, my lord. If your lordship wants, my lord, I can serve them once again.
You serve the supplementary.
But I have already given a copy, my lord, to my learned friend appearing for the state.
You serve the respondent number 6.
I shall, my lord. But in the
We are
meantime,
not
my lord, I shall be praying, my
disputing,
lord, for
the contentions that he was a member of Panchayat Samiti. In fact, we have also came across such facts, but my lord, we are yet to verify them. We have given two different, the SCFS has given 2 letters to the block development officer, concerned block development officers, seeking clarification whether he was actually a member of Panchayat Samiti when he applied or not. My lord, we are yet to receive a communication. As and when we receive, my lord, that official communication, we will take steps against him because he has made a false declaration in his affidavit, is point number 6, that he was a member of Panchayat Samiti. As far as, my lord, the petitioner is concerned, my lord, he was also ineligible because on the date of inquiry, his godown was incomplete. My lord, but we are not defending the license of respondent number 6 here, my lord. We under specific instruction I am submitting before lordship. But my lord, we are yet to receive that official communication by the block development officer.
12th of December.
And thereafter, again on 13th of January, my lord, we have given a reminder.
But that makes my case, my lord, even stronger.
My lord, I'm not in a position to dispute, my lord, because
as I said, my lord, this is a
my
very
officer is
well
also
stand by the state.
has also come across this thing from the website of the Election Commission. But my lord, the BDO is the concerned authority. My lord, he has to certify that whether that person, after getting elected, has resigned or not. Before he can resign before making an application. So, my lord, that is a benefit of doubt that can happen, that can work out in favor of respondent number 6, my lord. But till the time we receive, my lord, we are yet to, we will not take any steps, my lord, because we are yet to verify that.
You serve and come after a week. Okay.
But in the meantime, my lord, if there can, my lord, because as of now, my lord, he has not been distributing, my lord. He's not been distributing, no, my lord. You can, lordship can take, my lord, instruction from the state. He is not, my lord. That's my instruction.
He is not distributing?
Not distributing. Otherwise, I would not have prayed for stay, my lord. Lordship knows, my lord.
No, he is distributing or not distributing?
No, not distributing. Not distributing.
Who is distributing?
Well, the one who's been distributing for before the notification.
Kindly, my lord, pass it over, my lord. Within 5 minutes, I'll.
Yes.
I have not taken that instruction whether his allotment has been made or not. But kindly pass it over within 5 minutes, my lord. I'll inform that, your lordship.
No, he was selected.
He was selected. License was issued.
But whether he was distributing or not?
License has been issued. He has deposited all the requisite fee. Thereafter, as and when this petition was served, my lord, we have taken instructions from the BDO. We are yet to receive that instruction. And my lord, if he is found that on the date of
pass it over.
My lord.
Pass over.
Mother was a fair shop dealer. Kindly turn to page 14 of the repetition. The license which was granted to the mother page 14.
Savitri Bhomi.
So mother died on 27th of November 2023 at page 15.
Yes.
Date of death, 27 November 2020. The petitioner applied for on compassionate ground within the stipulated time, which will start from page 16.
Yes.
Page 20, if you also kindly turn to page 20. Acknowledgement is at page 21, 29th of December 20. Kindly turn page 21. Acknowledgement, receiving copy. Then all the documents I have annexed.
Yes.
Then kindly turn to my lord, page 25. This is the NOC by the other all legal in my favor. Kindly take Gita Rai, wife of Francis sister Rita Udhikari, Anita Pal, Rinki Bhoom. There are 5 legal heirs, including me. So 4 has given their NOC in the form of affidavit.
All sisters.
My lord, all sisters. Next page, page 26. You will also kindly read one paragraph, paragraph 16. That we have no objection if said Sudipta Bhomik, that is my client, is engaged an affairs of dealer in place of Savitri Bhomik, that we are sharing this affidavit for no objection in this episode in favor of Sudipta. Next page, you will also kindly turn up. The legal heir certificate has also been issued by the local Gram Panchayat, saying that there are 5 legal heirs. I have shown to your lordship out of 5, 4 has been given NOC in my favor. Page 38, you will also kindly turn up. Then get to it. Before that, if your lordship, just some documents I have placed before your lordship, page 30. The son of the petitioner is suffering for chronic kidney disease. Kindly see, madam, this is the document.
Yes.
Baby, kindly see top portion. Registration number, patient name, baby male Krishna Sudipta Bhomik. Have you lordship got my lord? The medical document which I have annexed, kindly turn to page 32. These are the medicines every day I required. And suddenly she became my lord unconscious. These all documents from the hospital also, page 33, 34, 35. The hospital document of Pune at page 36.
It is the son of the petition.
My baby.
Baby.
Then my lord, another hospital, 96, page 37. These are all documents.
Yes.
But after submission of application, a notice has been issued in favor of all the legal heirs, including myself, on page 38.
7th of March.
My lord. Hearing has been is to be taken place. My lord, hearing has been taken place. All the legal heirs, including myself, participated. During the course of hearing, they have also given their no objection in verbally. Then rejection. Kindly turn to page. Next page.
Yes.
Rejection of proposal for engagement of Sudipta Bhomik, petitioner before your lordship. With reference to the above, this is to inform you that the Director District Distribution, Procurement and Supply has rejected the prayer for engagement of Sudipta Bhomik as a paid dealer on compulsory ground in place of his deceased mother, late Shobita Bhomik, as he is receiving pension. But I am a retired military. I am a retired military. I shall show to your lordship. The next page, subdivisional control and intimated the same. Your lordship, kindly turn to page 41. Your lordship knows there are various schemes which provide jobs, LPG distributorship, petrol dealership as a special category. Retired, I have served the nation for more than the last 25 years. My daughter is, my lord, baby daughter is suffering. The rejection is that you are getting pension from the military office. All NOCs are there. Then next page, kindly see the scheme. First, my lord, page 41. The central government scheme to provide benefit to the retired employees of the military. Page 42 is another document.
No, what is page 41? That is the
41 is the central government notification.
notification.
My lord. In exercise of the powers to answer, this rule may be called to answer. They shall come into force in newspaper for appointment to any reserved vacancy in Group C post. A matriculate ex-serviceman which deals with ex-serviceman. Have a look at my lord. So these benefits are being provided. Retired from the military. Then all states are following the same.
Now, whether this notification allowed the petitioner to have a license, government license?
But your lordship knows, my
How
lordship, so far
specific
the,
is
your
that?
lordship heard numbers of cases so far the LPG is concerned. There is a reservation. So
Yes.
far the retail outlet dealership is concerned, there is a reservation also. For ex-serviceman, ex-military. So far this part is concerned, I do admit, my lord, there is no such reservation. But this is the rarest of the rare case, where a retired military is coming before your lordship, challenging the rejection of his application for compulsory appointment on the ground of getting pension.
We are around.
Rule is not always valid rigid. It is a beneficiary legislature. I am paying before your lordship, kindly enlarge the scope of this beneficiary legislature. Being ex-army. In all over India, all states provides special benefits to the ex-servicemen, ex-military. And considering the physical condition of the child also. All have been given, my lord, NOC. Admittedly, there is no dispute about the same. It is a family settlement that I shall apply for the same, because all are ladies, all are married. I am the only son. And rejection, if you lordship, kindly once again see what is the ground for rejection at page, my lord, 37, 38. 40. Just kindly come to my mind. With reference to the above, the understanding is directed to inform you that the proposal for your engagement as fair by chaplain on compulsory ground in place of your deceased mother, late so and so, has been rejected by the director distribution, procurement and supply. As you are receiving pension from the government and you are not only dependent, they are insisting so that other legal acts are applied. I have shown to your lordship there are other legal heirs who all are lady and all are married, residing separately in a distant place. The court's hands of the report is not, can be shut down. And now they have already declared a vacancy also. Kindly turn the last annexure of my petition, page 43. Serial number middle portion 39. In case of my mother license, the vacancy has been notified on 16th of August 2024, page 43. Serial number 39, middle portion. There are two serial numbers. One is the left-hand side and another is the middle portion. Serial number 39 is the vacancy arose due to the death of my mother. Possibly Mr. Sengupta may take instruction so far this part is concerned, my lord. But in the meantime, my lord, this election process may be stayed. These are my submission.
What is your submission?
It's a special case, I must say.
Milord, whatever my senior learned friend is saying, Milord, I cannot deviate. It's a beneficial legislation. It's for applicable for all. He cannot claim any privilege out of the beneficial legislature. What is the, Milord, the claim is all about? Claim is all about is a compassionate appointment. Compassionate appointment doesn't give any legal right. It's a scheme. It's a scheme to provide the financial support to the family who doesn't have adequate financial support to live in. Thereby, if I'm cutting something, it will be cutting from the Milord the regular manner. Those who are having the right over the Milord appointment, I have to cut it from the same. Today, Milord Lordship have seen a person has came up before your Lordship. He is having an adequate income, which is appearing at page 41. It means he has a support of the survival. Thereby, this compassionate appointment scheme would be frustrated. This has been elaborated in number of the judgment in the Supreme Court. Lordship knows far better than I do. One is Milord the Umesh Kumar versus State of Madhya Pradesh. Now the second thing is that Milord, so for the economical solvent people, Lordship kindly decide this point also. Whether a economical solvent people are seeking for a compassionate appointment, can that be given at any point of time?
Yes.
Because it is apparent he has not denied that he is financially solvent. This particular zone is a very Milord, I would say, has to be dealt with very sensitive manner. Milord, had it been a case, the family has no income, nothing, then they are coming within the zone of the consideration of the compassionate appointment. But fortunately or unfortunately, the family is having the income. He is having the Milord getting the pensions. So thereby, he cannot coming within the zone of the consideration even of the Milord economic insolvent man. He is economically solvent.
Yes.
Now if your Lordship kindly see, the page 17 once. Have your Lordship got it, Milord?
Yes.
Now kindly see page 17, part 4. Below down, Milord.
Part 4.
Part 4. Part 5, sorry, I'm sorry.
Part 1.
Last part 1.
Part 5.
Part 5. Other details. Monthly family income from source rather than the FPS deduction if he has no such and such. Income from sources is not to be around for the year 22,500. 1,500. Now kindly come back. Have you Lordship got it, Milord? Now kindly come to the Milord, the statute ones.
Yes.
Kindly straightway come to 1.10.
Yes.
Now, Lordship sees, Milord, the criteria has been laid down over here. What are the criteria? May I read out? In case of death or in case of the incapacitation on medical grounds subject to the satisfaction of the authority, Milord, kindly see one by one word. Incapacitation on medical ground. Is not.
You are reading?
Milord, from 1.20 onwards, West Bengal
1.20.
PDS Maintenance and Control Order 2013.
Okay, okay.
বইটা দেন একটা কোথায়
Yes, proceed.
Yes. In case of the death or in case of the incapacitation, it is not he is not falling under that category from the very outset. On medical ground, it is not even coming. Subject to the satisfaction of the authority of the or any existing dealer, prayer of any family member of the deceased dealer having no regular means of income. Lordship, kindly note that me. May be considered on compassionate ground if such prayer along with the formal application in Form C2 along with the Annexure 1 with the requisite fees as prescribed in such and such
corroboration document as per checklist of the no objection from other family member. This particular zone, no objection comes later part. First, he has to satisfy your lordship the incapacitations. And second thing is that, my lord, the regular means of the income. On a threshold, it appears that he is having an income. Now, lordship sees so another point, my lord, on the next part, the statutory limitations.
Yes.
Which has been done within the 120 days. I believe I have not, this has been done, so I am not taking that point. Now, kindly, now kindly see the AB part. The licensing authority may such and such corroborative document as per the checklist made by the licensee in his behalf, allow him to do so on examination of the inquiry report from L2 and comments of the SCF and from M2 with the approval of the director, if and only if one of the family member of licensee have no regular means of income, is inducted or substituted as partner or otherwise. The first criteria, my lord, he has to be proved that he is having difficulty in living. He has no income. And it proves that he has the income. That document itself shows that he is having the adequate income.
Yes.
Now, once again, I repeat, Millet, the essence of the beneficial legislature, rather the preamble of the beneficial legislature is to give the support to the family for whom doesn't have adequate support in the life for their earning.
Yes.
As I pointed out to your lordship, my lord, that this is not a right, this is a scheme. This scheme or the compassionate appointment, since there is no reservation or nothing, it is basically cutting from the general categories at large or the otherwise. Here, my lord, apparent that a person is having the, my lord, income. And I will not go by that, whether that is adequate or inadequate. But whatever the statute says, I have to go by that. He is having an income. After the death of that person, they are not falling into the water. They are having the financial support. Now they are asking for the, my lord, the same to be implemented, which is, my lord, according to my humble understanding, cannot be given, my lord. That's all, my lord.
Starts from the control order. Okay, completion. On first line, two set. First, 1-6. That page 1.2.
Yes.
In case of death or in case of incapacitation. So there are two types of compulsory appointment. One after death of the dealer, and another is on medical ground.
Yes.
Incapacitated. What is the position to run the business? Scheme is completion. It is not final and final. Your lordship knows, my lord, initially, this term was not included in the definition of family. Husband delivered? No, this term should also be. grandson, granddaughter was not in. Is for health? No. They should come in the definition of family. Widow, married daughter was not there also. These are all in terms of the judgment of this honorable. I have shown to your lordship, my lords, my child is suffering from a disease for which specific apartment 20,000 per month expenditure. This is a compassion appointment. State should have some compassion. A person is coming to your lordship showing that these are the position of my family. I get 22,000, I have not suppressed. In a month, after serving the nation for last 25 years, there are central schemes followed by all states to provide some compensation to the retired militants. Ex-servicemen. I am approaching the door of the court by saying this is a fifth case where court should enlarge its power sitting in the report. Even if I read in the, if I state in my application that I earned rupees 500 or 200, even they can cancel the thing. Because nothing has been stated whether there is any income, how much income. My learned friend rightly says whether it is sufficient or insufficient. I am saying this is insufficient to the extent that entire money goes for expenses of treatment of my daughter. So court should give some compensation so for this particular case is concerned, the exceptional case. These are my comments.
Yes.
And there is a vacancy.
Only one line to that extent, only one line, if your lordship so allows me. That the explanation to the legislature cannot be given in that manner. Insufficient or sufficient. Whatever is there, it has to be read into. Otherwise, Millard, it will change
The
the
statute is having no regular means of income.
Yes.
Correct.
This is the statute.
Correct.
It should be
Millard, the
added to maintain the
Umesh Kumar Nakwal versus State of Millard, Haryana, and other judgments. I can show to your lordship, Millard.
And there is a judgment of this
Millard,
court.
this is not opening up because I do not know why. I was trying to internet, is not working, unfortunately.
But there is
I'm
a
trying
judgment of this court. I'm
There is-
extremely sorry I have not
Millard,
got that.
there are 3-4 judgment, even inclusive of the division bench also. Division bench, one particular judgment. Justice Lapita Banerjee appointed the same, and then the Justice Mantha has Millard set aside the same. Millard, that judgment also I will brought. Millard, I have appeared on the same. He held Millard, upheld the Millard the principle that the financial insolvency after the death of that person, whether
Okay,
that
you hand it over to me.
I will hand it over.
And there is a judgment
Second
of
up.
the Statutory also. In
Sorry,
the same case,
Today.
Millard, if it is, I could open it up. I can.
there is a judgment of
আচ্ছা ঠিক আছে তাহলে পরে করবো
military.
Then come on tomorrow.
tomorrow কেন হবে সোমবার করি
In the meantime, proceed করছি না।
না না তুমি আবার এইসব গুলো চেও না দাদা এইসবগুলো হলে হয় না
বল তারপর একজন অ্যাপয়েন্টমেন্ট হয়ে যাবে তখন
this
তোমার
cannot be given
No, I shall dispose of the matter on that point. No issue. There is a point of law on it or consider it.
Thursday yes
Thursday.
oh Thursday is the holiday
Thursday, I don't have the any details.
Huh?
Next Wednesday. Next Wednesday. Day after tomorrow. Come on day after tomorrow. Okay.
I have no problem
Come on day after tomorrow. Matter heard in part. Let the matter appear day after tomorrow. On
এটা
top
তো
of the
ইউনিটি
list
হবে
at 10:30.
item number
The previous matter, just I have taken instructions, Milord, in the previous matter, which was with Panchayat Samiti point was there. Under my instruction, Milord, as per my instruction, he is distributing. The allocation has been made for the month of January, but I will beseech your lordship to let the status quo continue for this month. And Milord, next week, Milord, we will be coming in this month only. If your lordship so pleases, Milord, your lordship can set aside the license.
Now, what is your query regarding his
Milord, whether
membership?
on the date of his application, because Milord, his name is there in 2018 website that he was elected. But my lord, it so happens that many people at the time of application, they resign before the BDO and then they apply. So on the date of application, he is no more a member of Panchayat Samiti or any local body.
I will take up the matter at 2 p.m.
No, that,
My lord, that
this can be done, for your lordship conscience also. Since, my lord, it is the BDO who is supposed to answer this, and they've already written twice, my lord. Lordship, my lord, in that case, my lord, give direction on the BDO, my lord, to disclose, my lord, and as of, my lord, since it's coming.
How I can direct the video?
My lord, we will come.
Them
My lord, we will come, my lord, on next week.
Let the video be replied.
We will,
Otherwise, all the authority can be tagged in the matter.
my lord, we'll come next week, my lord. Kindly take it up any day next week, my lord. We'll apprise your lordship and it can be disposed of.
No, he prayed for necessary order. He prayed for any order. He prayed for interim order.
That, my lord, I'll be opposing today because, my lord, he is ineligible. He cannot challenge this. My lord, we are taking a
Legally,
he is ineligible, my lord.
matter which was raised before this court is appears to be illegal to be done by the Respondent number 6.
My lord, we are yet to ascertain that, my lord. We are yet to ascertain. We have
In this month he is distributing.
he is already distributing. Allotment has already been made.
Make it easier, my lord, lordship. Easier, my lord. Today, my lord, no interim order will pass, my lord. Since, my lord, it is coming from Mr. Singh, he is saying that there is distribution. I have no reasons to doubt, my lord, what Mr. Singh said, my lord. He is otherwise a very fair gentleman, my lord. So let it be passed, my lord. Let it be passed over a week, my lord. And then after a week, my lord, it is himself saying, my lord, he will definitely ascertain, my lord, whether he was
Item number
25.
25, my lord.
next week.
next. Okay.
Grateful, my lord.
Not this week. Okay.
If your lordship resumes the court proceeding, my lord, seeking one indulgence, my lord, my lord's list is indicating that the Monday, Tuesday, and Wednesday contempt matters will be taken up. But somehow or others, my lord, it is not being taken up, my lord. I have some urgency in contempt matters, my lord. Those are running in your lordship's list, but not been taken up. It's being getting down day by day, my lord.
The
It's
matter
60, starting from 60, I have 67 item number.
67 today's list.
My lord, it's a contempt application.
Okay. Contempt applications.
Starts from perhaps 60, my lord, 60. Kindly give some preference to the contempt application, my lord. Any day, for your lordship's convenience, my
How
lord.
many contempt applications are there?
So many are there.
Why so many contempt applications?
I have only one.
Very.
May-
I'll
any-
take note of. No issue.
My lord, any day, any day.
Get on the list.
For the petition. I have concluded my submission, then my learned friend appearing on behalf of the Hindustan Petroleum Corporation also argued. Today I shall give reply. Matter relates to my lord. Transfer.
Who is appearing?
Mr. Vishwanath Chakraborty. He
Okay, Mr. Chakraborty is appearing.
yes, must. Transfer of customers.
Yes.
My learned friend's submission was twofold. The first submission, as I understood, that
Yes.
relying on some clauses of dealership agreement, my learned friend sought to make out a case that the interim order dated 19th August 2023 at page 164 has not been issued relying on the circular dated 4th January 2018 or 8th January 2018. His submission was that they have invoked section 2, clause 2B of the agreement.
Yes.
And the next submission was that there is an arbitration clause. So without exhausting the remedy, we cannot come before this court. There is an alternative remedy. So for the first submission is concerned, my lord, if you should kindly turn to the agreement at page 108 of the writ petition. My appeal lordship had come at page 108 of the writ petition.
108.
But this is the agreement executed by and between the Hindustan Petroleum Corporation Limited and my client.
Yes.
My learned friend has relied on clause 2A.
Yes.
The corporation hereby applies by the dealer and the dealer hereby accepts this appointment as well so and so on principal to principal basis for sale of the corporation's liquefied petroleum gas LPG known as HS gas in surplus so and so. In my lord, helpline so and so handwriting position. Operation will be areas of operation will be Howrah municipal area and the corporation of the so and so, thereby area of the corporation. Then another clause has been relied on, clause 3, subclause 3, page 2.
Yes.
Without prejudice to the above, the corporation shall so be entitled to record the dealer to effect minimum salary of HP gas if we are with the policy that may be formulated from time to time by the corporation shall be further entitled to its sole discretion to reduce, restrict, modify, or alter the area of the dealership territory and the declaration of corporation shall be so and so. But I shall rely another clause. Kindly turn to clause 5.
Clause
5. Next clause. The dealer will during the
Interrupting my learned friend at once, my lord. But at the reply stage, if my learned friend again reopens his case, then again I have to give my reply. Again, this will continue for all. He had got a full-fledged scope. He argued for 3-4 days in full-fledged.
I am relying on which you have relied on. The dealer will during the continuation of the agreement. confirm him to the effect that the sales in the area of specified in the so and so shall be entitled to without the consent of the dealer to enlarge, reduce so and so. Then the clause 5, the dealer shall make his best efforts to enrolling customers and canvassing blankets and for developing the increasing the said LPG distributorship. These clauses has been relied on my learned friend. And then, my lord, if you like to kindly come to page 151. Relying on these clauses, my learned friend's argument was that these clauses they have invoked, not the circular.
Yes.
Now, your lordship, kindly come to page 151.
151 is the letter.
Letter. 151 says, my lord, kindly see, this is the cause of action. What they have said, as new dealership is being commissioned on so and so Gramin Bhitorok at Kandberia, Rajpur, Bamla, so and so, kindly send list of 1,500 customers for transferring to HP. The list should contain proper details with consumer ID, full address, etc.
Yes.
So there is no mentioning of any area of operation. It is my choice whose name I shall forward for curtailment. Kindly take note of this. My learned friend case is that Howrah Municipal Corporation area is my operational area. Beyond this, I am functioning. So customers of this beyond this jurisdiction, they are curtailing. But the letter says, according to my choice, I shall forward the names of the customers, which is required to be curtailed by the corporation.
Okay.
There is nothing mentioned about operational area. There is nothing mentioned about any area. It is my choice. The case sought to be made out in the affidavit, not in the letter.
Yes.
Now, next page, I have given the details of the court cases pending, page 152, saying that you cannot do this because there is a restriction order passed by the division bench of the Bombay High Court at page 152.
Yes.
Thereafter, another letter has been issued by them. Kindly see the third paragraph, page 154. This context, we would like to inform you that the aforementioned judgment is applicable to the Maharashtra state, but not applicable to state of West Bengal. This writ petition had been filed in the BPCL. So, another point they have taken that the judgment which I have relied on, division bench of Bombay High Court, is not applicable to the state of West Bengal. And that since the same has been issued in against the BPCL authority, HPCL is not binding. Now, your lordship, kindly come to page 164. This is the impugned in the writ petition. Kindly see the date, 19th of August 2023.
Yes.
Please find the attached list of so-and-so consumers transferred from block transfer, Anand Haitpigal also. There is no mentioning of any area of operation or something else. Only customers. Now, your lordship, kindly take up the division bench judgment of Bombay High Court, which I have annexed. If all these points have been dealt with, considered and upheld by two division bench of our country, one is Bombay High Court and another is my lord Calcutta High Court. I shall show to your lordship all these points.
Learned friend has placed all these facts. These are repetition of facts, my lord. But at a reply stage, he can only if I have
taken replies, sir. You have taken the
arguments to deal with my case, then he can do so. Factually, he can't enter at this stage.
But kindly come to the division bench judgment of Bombay High Court.
It's like rehearing his entire case at the reply stage.
That page, my lord.
This is only argument of the.
I'm giving reply.
That
yes,
they have not followed the notification. They have.
But that has been dealt with by the Bombay High Court. That I want to show. Only that paragraph, not the entire judgment. Kindly come to my lord, page 53. The division bench judgment of the Bombay High Court. It starts from page 52. Two paragraph I shall rely upon.
Page
52. It starts from page 52. 17 July 2019 order.
Yes.
What was the challenge? Page 54. Kindly see one circular and the letter whereby the first paragraph, the customers have been taken away. These are the two communication was under challenge. Now, your lordship, kindly come to page 70. What my learned friend has submitted, just I am placing before your lordship. Page 70. so far the arbitration is concerned. Paragraph 11, page 70. Since he has taken this plea, when the same has already been settled, and our division bench gave seal and seal upon the same, kindly come to paragraph 11. We propose to first deal with the preliminary objection raised by Mr. So-and-so as to maintainability of the present petition. It was his submission that the dispute between the petitioner and the BPCL arose, that was the case against the BPCL, arose out of the distributorship agreement and are in the nature of contractual disputes for which an alternative remedy or arbitration is provided for the therefore. The petitioners are not entitled to invoke this court's jurisdiction. In our opinion, the question as to whether or not this court can exercise its jurisdiction is contractual matters, is no longer is integral. The petitioner have in the present petition not canvassed or pleaded breach of the distributorship agreement, but have assigned the impugned circular on the basis of it arbitrary, unreasonable, and irrational. The grounds of challenge would enable this court to exercise its jurisdiction despite the result of the distributorship agreement and or arbitration clause contained therein. In this respect, the apex court has, in the case of Whirlpool Corporation Limited, and held that the exercise of an alternative remedy would not preclude the petitioner from exercising jurisdiction. The same view has been taken by the Honorable Supreme Court, Ramanna Dayaram Shetty, International Airport Authority versus International Airport Authority, and Tata Cellular So-and-so. In view thereof, we reject Mr. So-and-so's objection as the maintainer of the writ petition. The issue which has been raised before your lordship, that there is arbitration clause, and the same issue has been considered by the Bombay High Court on the same circular.
Yes.
Now, your lordship, kindly come to the next page. So, for the second submission is concerned. This entire issue has been recorded. Paragraph 12.2. What is the consequence? Your lordship, kindly take note of this. What will be the consequence that has been taken note of the circular? Paragraph 12.2, A, B, C, D, E, F, and G also. The consequential effect of the existing distributor. How it will prejudice, that has been recorded. Your lordship, kindly see the subparagraph G. The result of the impugned circular will therefore be the distributorship prior to its 2006, just like my client, run the risk of losing their refill cylinders the moment they exceed 9,900, which a new distributor runs to such risk till he exceeds 15,000. That's the observation of the Honorable Supreme Court. The same issue. Transferring cylinders from me to newcomer. What is the effect? Then kindly come to my lord, page 76. Another issue which has been canvassed before your lordship by my learned friend. The issue are all settled. What?
Yes.
Page 76, paragraph 15. The clauses which have sought to place before your lordship, that has been dealt with by the Bombay High Court. Kindly see.
My lordship will give me a chance, my lord, to re-argue, my lord. That is what I want to indicate. It will continue going on like this.
Kindly see paragraph 15, which you have submitted. I sought to place before the Honorable Court that this point has already been dealt with, considered, and upheld.
Had already had the occasion to deal.
I have not dealt with your submission, sir.
So he is re-arguing practically.
Kindly come to my lord, paragraph 15. These clauses have brought to your lordship notice by my learned friend. Relying on second that distributorship agreement, Mr. So-and-so is entitled to enlarge, reduce, or modify the territory of the distributorship. Petitioners are therefore also entitled to reduce the number of customers. In order to deal with submission, it would be necessary for produce the clause 1B that has been placed before your lordship. Clause 1B, Roman 2, Roman 4. That is the all submission of my learned friend. Then kindly come. That has been recorded. Need not go through 2 and 3. Kindly come to my lord, paragraph 16. In our opinion, next page.
Yes.
In our opinion, the aforesaid clause is restricted to area of territory and not customers as being sought to be contented by Mr. So-and-so. We do not believe that a collateral of BPCL right to reduce the area of territory would also include a right to reduce the existing customers. Contrary to the submission, it appears that the distributorship agreement contemplates the action of causing the petitioner to increase their customers and not decrease the illustratively so and so that has been recorded. Just I have placed before your lordship this clause also, which has not been placed before your lordship. Kindly come to the next page, my lord. Legitimate expectation. Court taken note of that you are forcing a distributor to increase the customers. Infrastructure, labor, everything shall be enhanced. And now you cannot dealing the same. Kindly come to paragraph 7.
17.
17, page 79. The aforesaid proposed clause, which has been placed before lordship, being asked to Mr. Dhole's argument that the improved circular is contrary to the direction of legitimate expectation and promissory estoppel, and therefore violative of Article 99G. Because these clauses says the corporation will tell you that these are the number you have to achieve by increasing your infrastructure, engaging more laborers, construction of further go down. These are all my legitimate expectation. Extent of the petitioner's expectation. We have perused the various correspondences addressed to so and so. According to Mr. Dhole, a perusal of these communications would reveal that the BPSL and its officers have time and again impressing upon the petitioner to increase their sale and customer base. Illustratively, BPSL wrote to the petitioner so and so. The same, I have also been instructed to increase. The petitioners have at kindly come to the last two lines. The petitioner have at exhibit no non petition so and so, provided statement so and so. Then kindly come to our next page, only one paragraph, paragraph 18. With the aforesaid concern in mind, we now proceed to analyze the scope of the doctrine of promissory estoppel. Judgment has been relied upon. All these pages, then straight away kindly come to page 93. The operative portion of the judgment, page 93, paragraph 24 and 25. Mr. Swans, the last argument that in the absence of any case that the impugned circular is arbitrary or suffers for witness-based unreasonableness, the challenge of the petitioner to impugn circular cannot be sustained. For the reasons set out herein above, this argument holds no water, since we have already held that the impugned circular is arbitrary, irrational, and in at least violative the petitioner's vested rights, which providing for benefits according to the named benefits entirely differential. For this reason, aforesaid petition is allowed in terms of pair so and so, A and B, consequent to the impugned circular and impugned communication so and so. So, my lord, transfer of customers from me has been quashed and set aside, and the circular also. Holding that you are not invoking your power under the agreement, you are invoking the power following the circular, and there is a legitimate expectation. After forcing the distributor to increase your business by providing more infrastructure, you cannot take one morning, you cannot take it away. Then kindly come to the next page, Supreme Court. It starts from page 194, kindly come to page 97. All this bunch of cases against the BPCL comes on 9th May 2023 at page 97, then kindly come to page 100. They have filed an application for withdrawal of the same. Subsequently, another application has been filed to allow them to withdraw that said application. And matter is still pending, no injunction, nothing. It is admitted position.
Yes.
Now, on next page, Madras High Court. It is against my lord, Indian Oil Corporation Limited. Same principle. It starts from page 101. You will also kindly turn to page 103.
But I asked a question to myself, did my learned friend praise his judgments at his time of argument or not, my lord? If he has done so, can he again do so? Then I will again take these points, whatever he's dealing.
No, no.
But
yes, Mr. Sahara, you have already placed.
No. Why I am placing show? My learned friend.
He can't. Then he could have repaired.
Am I relying anything outside my repetition?
He has to deal with the submissions that I have.
Your submission is that Bombay High Court has considered. Your submission is that.
Oh, certainly not.
Issue is still open.
I do not know, perhaps.
But kindly come to page 103. Pair has been recorded.
Yes.
Same pair, circular and the transfer. Then kindly come to page 105. Binding effect.
Yes.
Paragraph 5. Therefore, the learned counsel would submit that even though the circular was struck down by the Bombay High Court, the judgment of the division bench would never so and so. Heard the submission of so and so on so and so, the improved circular has been quashed by the High Court of Bombay and it is non-est in the eye of law, and the matter is sub judice before the Honorable Supreme Court. It is not in dispute that the circular and application across the country, the validity of the circular was upheld when it was alive and operative. Now that the division bench of the High Court of Bombay has quashed and circular in the previous, it cannot be constituted to the operative within the region as per so and so till the Honorable Supreme Court takes a decision as to the so and so. The operation of the so and so is dead. So next submission was, it is not applicable to Kolkata. The Madras High Court says circular is same whether Bombay or Gujarat or something else. We are bound by the follow the judgment of the division bench. That was his third submission. Now, Your Lordship, kindly, I have submitted with Your Lordship that writ petition has been moved. Your Lordship, kindly see the order passed by Justice Chaudhary on 24th of August 2023. I am handing over a copy.
In this matter?
Yes. Kindly see what was the submission. Page 8. Kindly see page 8. Learned advocate for the, I am not relying on my submission. The learned advocate for the HPCL, respondent number so my learned friend herein, submits on the contrary that the circular dated so and so in the state of Maharashtra and Madras may be quashed and set aside, but the decision of the High Court of Judicial Bombay and normal so and so are not applicable in the state of West Bengal. I am surprised. Kindly take note of this. I am surprised at hearing such submission made by the learned advocate for the respondent 2, while judgment of a coordinated bench of another High Court has a persuasive value. Judgment of a division bench of another High Court is binding upon the single bench of another High Court.
Not praised by the learned counsel for the respondent.
Yes, his submission is that.
No, he is not submitted like
that. He had submitted.
We have preserved the video clipping as well. If so arises, my lord.
His submission before the learned
had arisen on the time.
Yes.
During argument before me, he has not pressed this.
This was not placed. I was not there. All right. This judgment has possibly not been placed before Your Lordship. Why I am saying so? Because this has been upheld by the division bench. That I shall show to Your Lordship. Kindly see the last paragraph. This permission has been recorded. Kindly see. Again, submission. Clause 2. Last paragraph of page 8. Page 8, last paragraph. The same submission that has been recorded before Your Lordship.
Yes.
Then, my lord, 4th January 2018, circular has been stayed by Justice Chaudhary. But the fact remains, my lord, 4th January is the mother circular. So far the HPCL is concerned, that was 9 January.
Yes.
Now, what happened, my lord? I filed an application. Kindly see the order passed in my application for modification of the order. And the learned single judge coordinate bench passed an interim order. Just one paragraph, my lord. This is the subsequent order on my application, last paragraph, page 2. In the meantime, number of beneficiaries catered by the petitioner as distributor of so-and-so cannot be curtailed till the disposal of the petition. But 2 appeals have been prepared against these 2 orders. First order, kindly see, my lord, the division bench upheld the judgment order of Justice Chaudhary. Kindly come to the next page, page 2. Holding that the same circular, you have exercised your power under the circular, not the agreement. Page 2. My learned friend submission, page 2, first line. Mr. Chatterjee, learned advocate for the appellant, has submitted that the circular dated 4th January 2018 has not been issued by the HPCL. The HPCL issued a circular on 9 January. Kindly take, my lord, the next paragraph. It appears that the circular dated 4th January 2018 was issued by the CJM to State LPG India, and in pursuance thereto, HPCL has issued the circular dated 9 January. Kindly take note of. The contents of the said circular are verbatim reproduction of the circular dated 4th January 2018, issued by the CJM LPG sales, and circulated to all the companies. It appears that the same circular was the subject matter of challenge in the Bombay High Court and in Madras High Court. The learned single judge has taken note of the judgment of the Bombay High Court, order dated so and so, in WP number so and so, decision of the Madras so and so, and thereafter passed the impugn order. Can you take note of? The order of the Bombay High Court was against the circular issued by the Bharat Petroleum Corporation Limited, and said identical circular issued Indian Oil Corporation Limited was the subject matter of challenge before the Madras bench of the Madras High Court. It is not in dispute that the SLP has been prepared by the BPCL and the Honorable Supreme Court has adjourned the SLP till so and so. It is still pending. In view of the fact that the order passed by the Bombay High Court and Madras High Court have not been stayed by the Honorable Supreme Court, the stay of the said notification by the learned single judge does not call for any interference. So, but all submission, all expression of the learned single judge has been accepted by Division Bench or High Court. Justice Vivek Chaudhary's first order. It is surprising to note. Next, under such circumstances, we do not find any reason to interfere with the order. Amendment number stand dismissed. But there is no whisper. Kindly take note of that. This order will not influence the learned single judge at the time of disposal of the writ petition. In some cases, Division Bench says we are not going through the merit of the case. Entire thing is open. But so far this order is concerned, it has sealed the order of Justice Vivek Chaudhary. All the points. Now, Your Lordship, the second appeal, so far the another appeal is concerned, another appeal has been preferred. Kindly take, my lord, this order. Two orders by Justice Vivek Chaudhary, two appeals. Kindly come to third page. In view of the fact that the issue are now to be decided by the learned single judge and there was no immediate necessity to transfer the so-and-so, we feel that the repression is reported to be hard on all points. On such consideration, we are not inclined to interfere with the passed by the learned single judge. So direction has been given upon the single judge to consider and dispose of the writ petition. In this case, my lord, that line has been recorded. All points.
Yes.
So, my lord, so far the Bombay High Court is concerned, all points have been decided. Now our division bench also says you are not invoking agreement, you are invoking the circular. And all the circulars of IOCL, BPCL and HPCL are same and identical. But what submission received? They have not preferred any SLP against any of these order that reached finality. This is the observation of the Honorable Division Bench. That circular are same. Once it has been interfered by any of the High Court, it is binding upon all. But lastly, my learned friend has submitted before your Lordship that so far the annexure. Kindly come to page 156 of the writ petition. 156. There are number of letters I have written to the oil company, annexing there is all the judgments. Kindly come to P13, page 156.
Yes.
Relying on this document, my learned friend submitted that this letter is a manufactured one. I have never submitted the same. This is a voluminous letter before passing the impugn order. It starts from page 156 and 163. Ends. All judgments I have once again enclosed along with my representation. Even thereafter, my delinking has been taken place. According to my learned friend, this is a manufactured document. I have never submitted it. Well, kindly come to para 26, page 15 of my writ petition. Page 15. But I have dealt with this in para 26. Kindly see. page 15 and 16, and then a copy of your petitioner's representation dated 14th August 2023 that I have shown to your lordship, page 156, is annexed here to and marked with the letter P30. I have categorically stated that that has been submitted before the oil company, before transferring the cylinder, before transferring the customers. My learned friend says, no, it has never been submitted, manufactured document. I have categorically stated in para 26. Now, how this para 26 has been dealt with by them, if you lordship kindly take up their reply, opposition, page 12, opposition filed by the oil company. Opposition, page 12, paragraph 15. They have dealt with para 26 of my petition. That is page 156. What is their statement? With regard to the allegations contained in paragraph number 26, 27, 28, 29, 30 of the said petition, said what are matters of record raised are denied in totality. In order to avoid proximity, it is stated that the respondent corporation acted in terms of clause 2A, 2.4 of the LPG distributorship agreement, so and so. Petitioner, it is categorically denied with the direction concern, so and so, arbitrary, unreasonable, unfair, but also it is further denied that the transfer of one so and so customer without name or reason is bad in law and is liable to be set aside, so and so. Well, there is no whisper that this letter has never been intimated to them. No submission, nothing has been recorded that this letter is a manufactured one. From the bar, so many things can be submitted. They have dealt with para 26 and page 156 of my writ petition. They considered in merit. There is no single statement that this letter has not been submitted before the oil company. Everybody should be cautious before making any submission before a court of law. It is settled principle of law that division bench judgment is always binding upon all the courts, at least to the learned single judge of any court of any all over India. Issue is pending before the Supreme Court.
Yes.
And kindly take up my prayer. What is my prayer? I have paid for quashing of the transferring order and also the circular, but recording the date is wrong, which has been clarified by the division bench. It starts from page 32. 31. It should be, my lord, 9th January. 4th January, it should be 9th January. That has been clarified by the division bench, prayer B. Division bench, presided over by Justice Show mentioned, has clarified this position that these are all similar. B, C is the communication whereby transferring has been given effect to. Has been clarified by the Honorable Division Bench. So this is my submission, Your Lord.
Clarify the points taken by my learned friend, my lord. First, I would like to take your lordship's attention to the division bench judgment of this honorable court, my lord, which has just been handed over of 28th of February 2024.
28,
my lord.
Yes.
The page 2 of the judgment, my lord.
Yes.
Mr. Chatterjee, learned counsel for the appellants, has submitted that the circular dated 4 January 2018 has not been issued by HPCL. HPCL has issued a circular on 9 January 2019, which is not under challenge. It appears that the circular dated 4 January 2018 was issued by CGM LPG sales to state LPG heads, and in pursuance thereof, HPCL has issued a circular dated 9 January 2018. The contents of the said circular
verbatim reproduction of the circular dated 4th January issued by such and such circulated to all anchors. It appears that the same circular was a subject matter of challenge in the Bombay High Court and Madras High Court. The Honorable Single Judge has taken note of the judgments of the Bombay High Court dated 3rd September in WP such and such, and the decision of the Madurai bench of the Bombay Madras High Court such and such, and thereafter passed the impugned order. The order of the Bombay High Court was against the circular passed by Bharat Petroleum Corporation Limited. Kindly marks this. And the said identical circular issued by Indian Oil Corporation Limited was a subject matter of challenge before the murder. But where does HPSCL come from? I asked this question to myself. My learned friend is making a submission today that it has been clarified by the Honorable Division Bench. No, the 4th January circular is now to be treated as a 9th January circular. There is not a whisper in the learned appeal court's order, my lord. It is not in dispute that the SLP has been preferred by BPCL and the Honorable Supreme Court has adjourned the SLP till such and such. We have been informed that the matter is pending. In view of the fact that the order passed by the Bombay High Court and Madras High Court had not been stayed by the Honorable Supreme, the stay of the said notification by the learned single judge does not call for any interference at this stage. But even if I take my learned friend's case on a little higher pedestal, I take a fact that suppose the Honorable Division Bench has indicated of the 9 January notification. My learned friend ought to have taken steps in the matter. Today, even if this Honorable Court passes an order by quashing of the notification, that's not part of the challenge before your lordship.
Yes.
That's going to be a bad order with deepest of respect, bad in law.
Yes.
In the affidavit, my lord, there is not a single whisper of my learned friend. Yes, this is the order that we are not challenging of the 4th January. We are challenging of 9 January notification. And another aspect, lordship kindly keeps in mind, my lord, in all the correspondences which I have placed, I did not trouble your lordship placing them again. In none of the correspondence, my learned friend has tried to deal with the dealership agreement. He has always tried to bypass the dealership agreement, tried to bring in a notification and casting a cloud over the entire issue. It's a plain and simple dealership dispute. Now, the second submission, my lord, that I want to indicate, my lord, if your lordship takes up the second order of the Honorable Appeal Court, which is dated 6th of March 2024.
Yes.
I need not trouble your lordship by placing the entire order. If your lordship casts to the last page of the order, page 3. In view of the fact that the issues are now to be decided by the learned single judge, and there was no immediate necessity to transfer of any further customer, we feel that the writ petition is required to be hard on all points. My learned friend has just made a submission that the Honorable Appeal Court had put in a seal in that. The Honorable Appeal Court had clarified to the fact that your lordship is going to deal with all aspects of the writ petition and pass an order being uninfluenced by any of the observations of the Honorable Appeal Court. On such consideration, we are not inclined to interfere with the order passed by the learned single judge, such and such and such. But another submission my learned friend has made.
I just reply.
My learned friend has invited this.
Okay, just clarification.
That in any of the only one document, which my learned friend says that there is no mention, my lord, at page 151 of the writ petition. There it was indicated in the email which was sent to them that as new dealership is being commissioned, Om HP Gas Gramin Vikrant as Rajkataria, Rajpur, Uluberia to Howrah.
Yes.
But this gives answer to everything, man. I have placed the dealership agreement. I have placed the letter of appointment. I have placed the emails that have been sent by us. I have placed a reply also to the letters, my lord, where we have categorically broken and indicated in detail the dealership clauses under which the limited number of customers have been transferred because of commission of a new dealership agreement on that basis. There is no iota, my lord, of bringing in mention of any notification. We are not invoked in notification. And the judgment with my learned friend are relying on the Bombay High Court and the Madras High Court. That was a case where the customers were being curtailed because by invoking the notification. That is not the case here. Lordship has to judge it by the facts of the individual case, my lord.
Yes.
Well, these are my submissions, my lord.
Amen. Now.
Okay, take them. Argument on behalf of the parties concluded, made CAV.
Get rid, much of
Obliged, my lord.
I'm getting rid, much of this.
Yes, thank you.
But I am appearing for the petitioner. I have more or less concluded my submission, my lord. In the last occasion, my lord, I have submitted for lordship, my lord, that the impugned order is bad because it does not disclose any reason. Your lordship kindly come to last page. That is when, my lord, page 206, last page. I have made elaborate submission, your lordship has already noted, my lord.
Yes.
I'm just to give the slightest reminder, my lord, to your lordship, that this order is under challenge, that is at page 206. Has your lordship got, my lord?
Yes.
Yeah. My lord, it starts from, you have been operating a B-side kerosene dealership of Indian Oil Corporation at Barakhamba Road, Bajarpada, District Birbhum, West Bengal, under the name and style of Mr. Roy and Company for sale and distribution of kerosene, light diesel oil on the terms and conditions contained in the dealership agreement dated 29 July 2009, executed between Srimati CRI, this is, who is, my lord, deceased now, Sri Vinay Kumar Rai and Srimati Nisha Rai, as well reconstitution of this said kerosene dealership agreement. Now, my lord, after the demerger, this is the entire history has been given, my lord. How it has been, since then you have approached various courts, etc. As your lordship got, my lord, so I am not reading it out. Now they have quoted that again after the death of surviving partners have reconstituted the firm with the second respondent and his wife, Nisha as partner. The heirs of CRI, except one daughter, Srimati Susila, have issued no obligation. That is admitted fact, my lord. The stipulation dealership agreement on the death of partner agreement would grant terminated is not a very fair clause. This is, my lord, quote. This is a quotation from the appeal court order. So I am not reading it out, my lord, again. Again, it is unquote, quote. Then, my lord, last order, last page, the order.
Yes.
In view of your failure to submit, only allegation is that in view of your failure to submit a proper reconstitution proposal in accordance with the extent policy circular as mentioned here in above, your retail outlet dealership functioning under the name and style of Mr. Ryan Company is terminated with immediate effect. No reason except that I have not submitted the reconstitution proposal as per extent policy circular. Now, my lord, from page 208, you will kindly come to once again to page 208, second paragraph. This is the observation of the Honorable Appeal Court.
Yes.
The stipulation in the dealership agreement, second paragraph, my lord, that on the death of a partner, the agreement between the appellant and the dealer would stand terminated is not a very fair clause. So termination upon demise of one of the partners cannot be fair clause. That has been held and that has been accepted by the respondent oil company. But again, on the same analogy, they have terminated their dealership. That is at page 210. No other reason has been given. The entire order does not say what is the reason, because there are certain observations of the Honorable Appeal Court, how they should consider my application. Now, my lord, your lordship find in that paragraph, so many observations were made. It is not illegal because in our opinion, any person can choose to business with a firm with a particular constitution. It is true that upon the death of a partner, partnership firm may be dissolved or it may be reconstituted. There is a state of uncertainty in it. Any person doing business with is unable to ascertain in case of reconstitution the credentials of the future partner of the firm. A firm is not a juristic entity, so an agreement of dealership with a firm is an agreement to do business with individual partners of firm jointly and severally. Therefore, when a partner dies, the person doing business with it may or may not be willing to do business with a partner of the constituted firm. The appellant is a statutory body. Now, my lord, it is enjoined with a duty to act fairly and reasonably in contractual matter. It should not act arbitrarily. On the contrary, its action should be rational and just. For the appellant to insist that agreement would permanently stand terminated on the death of partner is an extreme step. I am relying upon this matter. It would be reasonable for the time being. It was terminated. Therefore, the partners of the reconstituted firm and the appellant should have been given an option of entering into a fresh agreement. We have not given any option. Merely that you have not made application as per extent policy. It has been terminated. Only 2 lines there. There is no reasoning. In this case, there is no complaint. Your lordship kindly mark it, my lord. Complaint regarding the service rendered before or after the death of CRI. The appellant has permitted the firm to reconstitute itself from time to time. It has renewed licenses of the reconstituted firms for a long period of time. These all observations have not been considered. After the death of CRI, the firm has been reconstituted with the second and third respondent as partners. The appellant should not be concerned as to the dispute. Your lordship kindly mark, madam. There is a dispute with only one daughter, that is Susila Rai.
Yes.
And appellate court has already observed the appellant should not be concerned as to the dispute between the second respondent and his half sister. The appellant ought to have examined the past and present performance of the firm with regard to his business of a license under it while considering grant of a new license. Therefore, my lord, this simplicity by saying that you have not submitted the application as per extent policy, we are rejecting. Nothing has been considered what has been directed by the Honorable Appeal Court. They will have to examine my past and present performance. They will have to examine that whether they are entitled to consider the interstate dispute of the partners. Now, the partner who came before the court earlier, she also lost. She filed an appeal. She went back. She did not get her title perfected from the civil court as directed by the Honorable Court. Now, my lord, still, only because of this 2 lines order, my dealership has been terminated. And other points I have already, my lord, I have submitted for lordship, my lord. In fact, my lord, the writ petition was allowed. IOC preferred an appeal, but that writ court order was not set aside.
Yes.
Only certain observations were made, and IOC was directed to consider our case in accordance with their observations. Mr. Jadhav.
But I prepared a brief for a list of dates.
Yes.
When it considers by 7th July 1984, this is date when, my lord, Srimati C.R. Roy, since deceased, my lord, was appointed dealer by IOC for kerosene oil.
Yes.
Is it? Then, my lord, 27 September 2001, on an application made for conversion of the sole proprietorship business to a partnership one, IOC gave permission, whereupon the petition number 2 was inducted as a partner, and upon reconstitution of the firm under the name and style of Mrs. Roy and Company, a fresh license was granted to the firm to carry on the business dealership. Now, my lord, this reconstitution was done based on the same guideline, which is now, my lord, impugned before my lord that this is not binding on me. Previously, it was, my lord, followed up to the, my lord, last dot, and the reconstitution was availed, my lord, under the policy circular, my lord. Then, my lord, April 2006, an affidavit was filed by Srimati C.R. Roy stating that she had 3 sons and 2 married daughters. Then, my lord, 24th July 2009, further reconstitution of the firm, when along with petition number 2, his wife, petition number 3, was also inducted as partner. Fresh license after reconstitution. Same policy circular, my lord, was followed, implemented, and my lord, the petition number 3 before my lord, she was inducted as a partner while C.R. Roy was alive, my lord. Then, my lord, 29 July 2009, dealership agreement between IOC and Srimati C.R. Roy, and 2 and 3 was new agreement was signed upon induction of petition number 3, my lord.
Petition number 2, 3 and C.R. Roy.
My lord. Then 30th September 2000, my lord, C.R. Roy passed away, my lord, leaving behind 3 sons and 2 daughters, my lord, as per her declaration which she submitted earlier, my lord. Then, my lord, 11th November 2009, petition number 2 and petition number 3 submitted to IOC an application for reconstitution of the firm with themselves as partner. No objection certificate was granted by all the heirs and legal representatives of C.R. Roy except Srimati Susila Roy, who refused to give no objection. Then, my lord, 16th October 2008, policy guideline for reconstitution of retail outlet dealership made provision in the event of death of a partner that in case of partnership, reconstitution may be allowed with the legal heirs of the deceased partner and surviving partners. Now, this is the, my lord, requirement under the policy circular. However, if there is no legal heirs or the legal heirs have expressed unwillingness, then the dealership distributorship shall be reconstituted with the surviving partners. Now, this particular policy circular was, my lord, by the Ministry of Petroleum and Natural Gas. It is part of my affidavit in opposition. Now, my lord, based on this particular policy circular, my lord, all the oil marketing companies were directed to frame their own policy circular and implement the policy.
Yes.
So, my lord, this policy which is being insisted upon, my lord, by the oil company is, my lord, from the ministry, and says that these are the requirements when there is a death of a partner of a partnership firm who is a dealer, my lord. Then, my lord, the legal heirs of the deceased partner is to be either no objection or there, my lord, they should be inducted. This is the requirement. Then, my lord, 1st December 2008, revised policy guideline for reconstitution of retail outlet dealership containing substantially the same. So, my lord, based on, my lord, serial number 8, my lord, the oil marketing companies framed their own policy. This is 1st December 2008. So, the parent policy, my lord, is 16th October 2008. And from there, my lord, the 1st December policy has emanated, my lord, as per the direction contained in that policy. Now, if, my lord, briefly I place that particular policy circular, my lord, 16th October 2008. This is, my lord, page 18 to 23 of my affidavit in opposition. My lord, page 18 of my affidavit in opposition. If my lord kindly takes, my lord, you'll find the date on the right hand, right hand top, my lord. Kindly see the policy number is 19001 5 of 2005, IOC, Government of India, Ministry of Petroleum and Natural Gas. Then 16th October 2008.
Yes.
This has been addressed to the Director Marketing of the 3 oil marketing companies, my lord. Then, my lord, paragraph 2, my lord, kindly takes, my lord. The issue was discussed with the officials of OMC in various meetings, and a presentation was also made by OMCs. OMCs, my lord, all marketing companies. Based on the deliberation in these meetings, I am directed to forward herewith a set of broad guidelines on the issue. OMCs are requested to frame their own detailed guidelines based on the ministry's broad guidelines as soon as possible and ensure that the new guidelines should be made effective in any case not later than 1/12/2008. While framing the detailed guidelines, the following provisions may also be incorporated. Then, my lord, kindly text, my lord, page 20, my lord. This is the annexure to the policy, my lord. My lord, 1A, my lord. Reconstitution of at the stage of letter of intent LOI. Then, my lord, kindly skips, my lord, page 21. Page 21, kindly text, my lord, page, my lord, at the bottom, my lord, reconstitution of commission dealership
Page
distributors.
22.
Page 21, my lord.
Bottom.
My lord. Kindly see, my lord, the note, my lord, reconstitution of commissioned and dealership distributorships. So this is a commissioned dealership, my lord. So this particular clause is applicable in this case. Reconstitution will be permitted by induction of minority partners only after 5 years of commissioning of dealership and distributorship. So, my lord, the previous two inductions were based on this, my lord. After 5 years, CROI wanted to induct his son. So that was allowed, my lord. And this was followed in extento, my lord. Then kindly text, my lord, 4, my lord. My lord, 5, my lord, in fact, because this is a partnership firm. In case of death of one of the partners, page 22, my lord. In case of death of one of the partners, the partnership shall be reconstituted with the legal heirs of the deceased partners and surviving partners. However, if there is no legal heir or legal heirs has expressed unwillingness, the dealership shall be reconstituted with the surviving partners. Well, this is verbatim, my lord. It has been taken from here, and my lord, the oil marketing companies have put it in their policy, which has been circulated to the oil dealers and distributors of the my lord, oil marketing companies.
So the issue is that when one partner died,
My lord.
so either brought all the legal heirs to the partner in the partnership,
My lord.
otherwise,
Or no objection, my lord. No objection from them will
objection.
suffice. The surviving partners can continue.
Can continue the dealership.
Because, my lord, the dealership agreement says, my lord, upon the death, if it is sole proprietorship firm, the agreement will come to an end, my lord. Even in case of a partnership firm, if one partner dies, my lord, the dealership agreement will come to an end. So if a party wants to reconstitute, then this particular clause, this particular policy circular is to be followed. This is the requirement, my lord, under the guidelines from the ministry, my lord. Now, my lord, in this particular, I was, my lord, at page 2 of my list of dates.
Yes.
Then, my lord, after the, my lord, the second reconstitution, my lord, the distributor, the dealers, my lord, they submitted a partnership agreement between them, deed of partnership between CROI and petition number 1 and petition number 2, serial number 10 of my list of dates, my lord. Now, my lord, 29 July 2009, dealership agreement between IOC and CROI and petition number 2 and petition 3, clause 45B at page such and such, writ petition. My lord, this particular agreement, 2009 agreement, also contains clause 45B Roman 2. My lord, I will place 45 and 46, my lord, I will place that, my lord. Then 30th September 2009, my lord, CRO expired, leaving behind 3 sons, Binoy, Sanjoy, Ranjoy, and 2 married daughters, Srimati Susila Roy and Srimati Chanda, my lord.
Yes.
Then, my lord, 11th November 2009, petitioner submitted proposal for reconstitution of the firm with the petitioners number 2 and 3 as partners. One of the married daughters, Srimati Sia Roy, Susila Roy, refused to give no objection certificate. Then, my lord, 16th November 2009, IOC returned the application because application was not made as per the format and because all no objection certificates have not been enclosed. This is at page 82 to 91 of the writ petition. My lord, kindly text page 82 to 91, my lord. Well, this is the letter from the petitioner firm, my lord. We are, my lord, this is a letter from IOC, I'm sorry, my lord, in response to their letter submitting, my lord. Well, we are writing to the petition number 1. We are in receipt of your application for reconstitution of Messrs. Roy and Company on the demise of Srimati Sia Roy, partner of your firm. While perusing the application, we find that you have not applied in the format as specified in policy for reconstitution of RO SKO LDO dealership dated 1/12/2008, which has already been circulated to you. You are therefore requested to apply in the format, copy of which is enclosed herewith. Kindly note that you have submitted photocopies of affidavits of no objection. Kindly note this, my lord.
Yes.
Kindly submit all no objections in original along with their application. Kindly go through the instructions and formats carefully and submit all documents as required immediately, enabling us to proceed further. Should there be any difficulty, kindly get in touch with us. Now, this is the my lord. The next page, page 83, is the reconstitution policy, my lord. Clause 5, my lord, here is 2.5, my lord. 1.5, I'm sorry, my lord, it's not legible. It is same, my lord, which I have placed. In case of death of the partner, the partnership firm shall be reconstituted with the legal heirs of the deceased partner and surviving partners. However, if there is no legal heirs of the or legal heirs has expressed unwillingness, the dealership shall be reconstituted with the surviving partners. Then, my lord, page 87 is the application for reconstitution. My lord, details. What are the formats requirements have been spelled out in page 87 onwards, my lord.
Only 1 year.
One year has not, my lord, has withdrawn, my lord. She has not given her.
Has not given the no objection.
No, my lord, we are not looking into the interest of the other legal heir who has not come forward or who has not joined the partnership or not given no objection. Our concern is, my lord, the implementation of the policy circular. My lord, we are only looking to that extent whether the policy circular has been followed or not.
That means all the legal heirs has to be submitted no objection.
No objection. No objection, or my lord, they may be included in the form, may be included in the reconstituted form, my lord. Either way, my lord. Now, my lord, in this particular case, the other partners who have given their no objections, the originals have not been submitted till date. This I have said, my lord, it is recorded here in that letter, my lord, page 82. And then, my lord, this is also reflected in the impugned order that the original no objection from the other legal heirs who are supposed to have given their no objection has not been submitted. Page 82, my lord, kindly see. Kindly note, my lord, the paragraph. Fourth from top, my lord. Kindly note that you have submitted photocopies of the affidavits of no objection. Kindly submit all no objections in original along with the application.
Yes.
Then, my lord, page 92, my lord, kindly text page 92. 5th February 2010. This has reference to your application dated 11/11/2009 and 25/11/2009 and our letters reference dated such and such on the subject mentioned above. As required, video or letter dated 16/11/2009, you have not submitted the family tree of the late CRO duly notarized. Reconstitution of retail outlet.
92 year reading.
My lord, page 92.
Yes.
Page 92. 5th February 2000.
Yes.
As required, video or letter dated such and such, you have not submitted the family tree of late CRO duly notarized. Reconstitution of retail outlet SKO dealership have to be done in a time-bound manner as prescribed in the policy for reconstitution dated such and such. However, your non-submission of document as required has resulted in inordinate delay. Therefore, your application is being returned herewith for resubmission along with requisite documents. So it was again returned, directing them to resubmit, my lord. Then page 93, my lord. This has reference to our letter on the subject, with which we have returned your proposal for reconstitution of SKO LDO dealership after demise of late CRO for submission due to infirmities. However, till date, we have not received any further proposal and we therefore request you to submit your proposal complete in all respect within 15 days from the date of receipt of this letter, failing which corporation shall be constant to take action as per policy. A comprehensive list of documents which are required to be submitted with the proposal in prescribed format is attached herewith for your reference. My lord, page 94 is the checklist, my lord, the documents which are required. Next page, my lord. Then, my lord, page 95, my lord, is the letter from the petition number 1 company, my lord, petition number 1 form. This has reference to your letter issued under reference number such and such on the subject captioned above. By the said letter, your good self asked us to submit proposal for reconstitution of the form, complete in all respect. Within 15 days from the date of receipt of letter, a checklist of document is to be submitted with the reconstitution proposal has also been forwarded therewith. From the checklist, it appears that the following documents, amongst others, documents have been directed to be submitted with the reconstitution proposal, that is, succession certificate from the court of law, deed of relinquishment from the legal heirs not proposing to join the dealership, and deed of dissolution of the existing partnership. In this regard, we shall like to draw your kind attention towards clause 22 of our partnership deed dated 24th July 2009, whereby it has inter alia been agreed upon by the partners that upon death of any partner, the other partners will be permitted to continue with the firm, and the existing partners will have to meet up the entire liability of the firm to enjoy the benefits of the firm. Upon accepting the said partnership deed dated July 24, 2009, an agreement was entered into between IOC and all the partners of the firm 29 July 2009. In view of the nature of the deed of partnership, there is no scope for interference of any legal heirs of the deceased partner in the business of the partnership firm in any manner whatsoever, and accordingly, the succession certificate from the court of law and or the deed of relinquishment from the legal heirs not proposing to join dealership are not required to be submitted with the reconstitution proposal. So far as the deed of dissolution of the existing partnership is concerned, it is stated that after the death of one of the partners, the existing two partners will continue to operate the partnership firm, and accordingly, the draft deed of proposed partnership along with the other documents mentioned in the checklist will be forwarded with the reconstitution proposal, because the deed of dissolution of the existing partners as sought for is redundant. Please take necessary steps for reconstitution. So, my lord, they entirely dispute our contention. They say that our partnership deed says that the partnership will not get dissolved upon the death of a partner, but it will continue. Now, the petitioners are seeking to bind IOC with their partnership deed, which is inter se, my lord, the partners. A partnership deed cannot bind a third party, my lord, who is not a party to the agreement. And moreover, my lord, after this particular partnership deed, the petitioners have signed a dealership agreement, which clearly says that the policy circular of IOCL, the dealership will come to an end upon the death of the any of the partners, and they have signed that agreement. It is not that they were not aware of it. So, the subsequent agreement will prevail upon the previous agreement, my lord. Here, my lord, the agreement, the dealership agreement will be binding upon the petitioner as well as upon the IOC. So they cannot bind us with a particular agreement which is entered between them, my lord. We are nobody to approve a partnership or to the terms and conditions of a partnership. Now, my lord, after this letter, my lord, our kindly sees, my lord, they have submitted this reconstitution, page 97, application for reconstitution of the commission dealer. Now, they have completely. They have said that they are not entitled to submit the no objection or the, my lord, the deed of dissolution of the partnership, and they are insisting that based on these information, the firm to be reconstituted. Kindly see, my lord, page 99. This is a checklist. They have given proof of identity attached, serial number 4, succession certificate not attached or not applicable, whichever way it is read, my lord. Then page 5, serial number 5 at page 99, my deed of relinquishment, legal heir of deceased partner not applicable. So they are clearly, my lord, defying the particular policy circular that these are not applicable. The standard affidavit regarding non-conviction attached, affidavit if in service not attached, passport size photographs pasted, copy of last dealership agreement attached, draft deed of copy of deed of dissolution of partnership not attached. Not applicable. Not applicable. Not applicable. So all NAR, my lord, not applicable. Then rest, my lord, are attached. Now, well, after this, my lord, this is the final letter from IOCL, my lord, page 100. Please refer to our earlier letter dated such a 5th February 2010 and letter number such and such 19 July 2010 regarding reconstitution of ESCO LDO dealership and your letter dated 20th August 2010, received by us on 16th August 2010 regarding the subject. Kindly note that your proposal for reconstitution video or letter dated such and such is incomplete, since you have not submitted all documents as required video or letter dated 19 July 2010. Your proposal is being returned for resumption, resubmission incomplete from within next 7 days, failing which action shall be taken as deemed fit. So this was the last, my lord, letter from us. This was impugned, my lord, in a writ petition before this honorable court. And my lord, the writ court order, my lord, is starting at page 101, my lord.
In this matter,
My lord, page,
yes,
it starts at page 101. Kindly come, text, my lord, page 108. My lord, the relevant portion I'll place before my lord.
yes,
My lord, kindly text 100, my lord, from bottom, my lord, 7 line, my lord. In
Paragraph
such
13.
paragraph
13.
My lord, in my 13. Oh, where is my number? In such circumstances, my lord. In such circumstances, merely because of policy guidelines,
Just
page 118.
118. 118.
118, my lord. I'm sorry, my lord. 118, my lord. 118. I'm sorry. In such circumstances, my lord, 7th line from what? In
Yes.
such circumstances, merely because the policy guideline says that in case of a death of one of the partners, the partnership shall be reconstituted with the legal heirs and surviving partners, the same cannot mean that it has to be interpreted in such a manner that even persons who are strangers to the deed agreement and who are not parties to the dealership agreement or the deed of partnership must firstly be satisfied for the reconstitution of the dealership agreement. If other legal heirs now want to be inducted, then they must first get their title perfected through a properly constituted civil suit before an appropriate court of civil jurisdiction. But the corporation cannot at this stage insist that the strangers to the partnership deed must also be a part of the reconstitution partnership. Under such circumstances, this court holds that the IOC cannot refuse to renew the license of the petitioner number 1 under the 1968 control orders, nor can they refuse to allow the reconstitution of the partnership firm of the petitioner number 1 at this stage. Under such circumstances, this writ petition is allowed, directing IOC to allow reconstitution of partnership firm of the petitioner number 1 without insisting on the induction of the respondent number 6 at this stage. Now, my lord, the court has, my lord, has gone into that we are insisting upon the induction of respondent number 6, that is, my lord, Susila Roy. That was not the case. All along, my lord, our contention is that this is the demand of the policy circular that they submit a no objection from all the legal heirs. Now, what they have not done, they have not submitted deed of dissolution. They have not submitted original agreements of no objection from all the partners. They have and they have not submitted even the photostat copy or any document from Susila Roy that she has given consent to. She has shown as well, it's not to join or to join the firm. So whichever way, madam.
Okay.
Now, my lord, at the same time, the respondent number 6 is given full liberty to get her rights declared and title perfected in a duly constituted civil suit. And if she succeeds, and only then she would be entitled to claim induction, including reconstitution of the firm in accordance with law. But till her rights are not declared and till her title is not perfected by a decree in which all heirs of C.R. Roy and Narayan Rai are parties, this partnership, the subject matter of this writ petition, cannot be allowed to become defunct. The writ petition is accordingly disposed of. Now, my lord, this order was impugned before, my lord, this honorable court, before the division bench, my lord. Page, my lord, this was also challenged by my lord Susila Roy, who was respondent number 6 in the earlier writ petition, my lord. Page, her appeal was, my lord, dismissed for non-prosecution. Page 121 is the, my lord, the order.
Appeal of Sheila Roy.
No, Susila Roy, my lord.
Susila.
My lord.
Yes.
This was dismissed for non-prosecution, my lord. Then, my lord, kindly takes page 124. My lord, the appeal preferred by IOCL was disposed of by a judgment on order dated 7 December 2017.
Yes.
My lord, the Indian Oil Corporation Limited, through its manager, have preferred this appeal. It is against the judgment, page 124. Page 124. It is against the judgment and order dated 1st September 2011, passed by Justice Tapan Sen in such and such. My lord, the facts are these, my lord. Several years ago, Srimati C.R. Roy was carrying on a partnership business as dealer of kerosene under the appellant. Gradually, she became old and infirm. On 27 September 2001, she converted this proprietorship business into partnership between herself and her eldest son Binoy, the first respondent. The partnership was styled as Mrs. Roy and Company, having its place of business at Bamakhapa Road, Bajarpada, Post Office and Police Station, Rampurhat, District Birbhum, West Bengal. The appellant accepted this reconstitution. On 24 July 2009, the firm underwent another reconstitution. The wife of the first respondent, third respondent, was taken as a partner. A deed of partnership was drawn up and executed by the partners of the reconstitution firm, Mrs. Roy and Company. The appellant accepted this reconstitution also, and on 29 July 2009, granted it a fresh license. On 30th September 2009, Mrs. C.R. Roy died. At this point of time, it is necessary to mention that legal heirs of Mrs. C.R. Roy, apart from Binoy, she had two other sons, Sanjay and Ranjoy. She also had two married daughters, Srimati Susila Roy and Srimati Chanda Roy. On 11th November 2009, the second and third respondent made an application to the appellant to reconstitute the firm by themselves. Together with this application, they submitted 3 no objection certificates from Sanjay, Ranjoy and Chanda. However, their eldest sister, Susila, who is about 15 years older than Sanjay, refused to submit her no objection. The dispute in partnership has its roots in the succession of the estate of C.R. Roy. Sur Ratan Roy, Raman Roy, had 2 wives, whom Sia was elder. The second wife, Lalita Roy, Susila Roy is the daughter through C.R. Roy. Binoy, Ranjoy, Sanjay are the offspring of the second marriage. The allegation against Binoy is that he is trying to grab his father's property. Now, it is very important to note certain terms and conditions of the dealership agreement between the appellant and Roy family. Clause 45 and 46 are set out. 45, notwithstanding anything to the contrary herein contained, the corporation shall be at liberty at its entire discretion to terminate this agreement forthwith upon or at any time after the happening of any of the following events, namely, if the dealer shall commit a breach of default of any of the terms, conditions, covenant, and stipulations contained in this agreement. B, upon the adjudication as insolvent were not applicable, the dissolution of partnership dealers firm not applicable, or the death. Roman 2 is important, my lord. The dissolution of the partnership of the dealers firm, or the death or adjudication as insolvent of any of them. So, my lord, here death was the issue.
Yes.
Then, my lord, other my lord are not relevant. Kindly skips, my lord. Then page 129, my lord. Clause 46, my lord. Notwithstanding to the contrary herein contained, in the event of dealer being a partnership firm, the agreement shall automatically come to an end and stand terminated upon any change in the constitution of the firm, whether by retirement or death of any partner, induction of a partner. So I pause here for a moment, my lord. This clause clearly says that upon death, the agreement will come to an end, my lord. And this starts with a non-obstante clause, my lord, notwithstanding to the contrary herein contained.
Yes.
In the event of the dealer being a partnership firm, the agreement shall automatically come to an end. So no further action is required, my lord. Come to an end and stand terminated upon any change in the constitution of the firm, whether by retirement or death. So in this particular case, it is death, my lord.
Yes.
Induction of a new partner, otherwise. Otherwise, howsoever, unless after a receipt of a written notice from the original surviving partners of the dealer firm of such death or retirement or induction, the corporation shall have expressly agreed in writing. So, my lord, this is the second part of this clause. If upon intimation from the surviving partners, if the corporation if the corporation shall have expressly agreed in writing to continue the dealership with the surviving partners or with the reconstitution firm. So, my lord, here, my lord, we have said we will reconstitute provided you follow the policy circular. So, agreement has come to an end. It is automatic, my lord. I don't have to do any further action in the matter. Here, my lord, after termination, after this particular invocation of this clause, my lord, we offered them to reconstitute by following the policy circular, my lord. Now they are saying it is not mandatory for us to follow the policy circular.
Yes.
For the reasons which they have stated, my lord. Now, my lord, for a second, my lord, kindly pause there for a moment. Believe, my lord, suppose, my lord, if it is an agreement between two individuals, my lord, here Indian Oil is not an Article 12 authority. It's a commercial agreement. The contract is very explicit between the partners. So if I say that agreement has come to an end, and if you want to continue, these are the parameters you have to follow and continue. Is it, I mean, something which I'm asking, my lord, my lord, can be considered as arbitrary or this has to be, now, my lord, I will place, even in commercial contracts, Article 12 authority cannot be, I mean, bound by the other parameters of the, my lord, section Article 14. My lord, it's a commercial contract, my lord. It's a commercial contract. Upon their appointment, they have entered into this agreement after knowing fully well, my lord, the different clauses. This particular agreement has been followed. My lord, there are three stages at which this agreement has been reconstituted. At every reconstitution, this agreement was, my lord, newly entered into. This particular clause was all along there in the previous two agreements.
Yes.
No. The corporation shall have expressly agreed in writing to continue the dealership with the surviving partners or with the reconstituent firm. Any supplies of the products made by the corporation subsequent to the death or retirement or a partner or induction of a new partner, or without knowledge of the death or retirement, with or without, my lord, with or without the knowledge of death. So, my lord, friend submitted that the supply is still on even after termination and all that. So, my lord, this clause will take care of that, because supplies made even after that will not come in the way, my lord. Not doomed to be conferred any, kindly see, my lord, under any or any other action on the part of the corporation under or in pursuance of this agreement subsequent to such death or retirement or induction in favor or in relation to the surviving partners and or the reconstituted firm shall not be deemed to confer any dealership or other rights in favor of the surviving partners or the reconstituted firm, unless and until the corporation conveys in writing its specific approval or assents to confer any dealership or other rights upon the surviving partners and or the reconstituted firm, as the case may be, and the corporation shall always be at liberty without any previous notice to discontinue, withhold or stop any such supply or perform any such act as it deems fit at its discretion. Now, my lord, the findings of the the Honorable Division Bench, my lord, we thus notice that if a dealer with the appellant is a partnership firm, immediately upon death of a partner, the agreement between the parties come to an end. The appellant, however, retains the power to continue its business with the reconstituted firm. The deed of partnership dated 24th July 2009 contains the following provisions. Well, 20, admission, that in case of admission of any new partner or partners for overall interest of the firm, they may admit any new partners with their mutual consent, subject to prior approval of the Indian Oil Corporation Limited and the licensing authority under the West Bengal control orders. Legal area, that if any one of the parties to this indenture is died or is become insolvent, the other party is permitted to continue the firm after fulfillment of the necessary requirements, and only in that case the existing party will be entitled to continue and run the firm smoothly. But in that case, the existing party shall have every duty to meet up the entire liabilities of the firm, and after that the existing party will be eligible to enjoy all types of benefits. Prior approval, my lord. That notwithstanding anything contained herein, it is hereby agreed and stated by us that any change in the reconstitution of this partnership shall be with or without prior written approval of the Indian Oil Corporation Limited. So, my lord, limited without obtaining such written prior consent, no change shall be effected. So we have two agreements. One is the dealership agreement between the appellant and the partnership firm. The other is the partnership agreement between the partners of that firm. The partnership firm operates as licensee of the appellant. By operation of the said clause in the dealership agreement, upon the death of CROI, the relationship between firm and the appellant come to an end. However, the second and third respondents are very strong in their belief that in spite of objection of Susila Roy, they are entitled to continue the partnership without her and do business with the appellant. Mr. Chaudhary, learned senior advocate for the appellant, drew this court's attention to a policy statement of his client relating to reconstitution of commission dealership distributorship. In case, my lord, that particular clause, my lord, from the policy guideline was quoted, my lord. In the contention of Mr. Chaudhary is that on the death of CROI, the partnership firm could only be reconstituted with her legal heirs and the second and third respondents. Of course, the second respondent is one of the legal heirs of CROI. Any other reconstitution would not be automatically recognized by the appellant. There had to be an express agreement. Since Susila Roy, one of the daughters of CROI, did not consent to the reconstitution of the firm with the second and third respondents as its partners, the reconstituted firm could not be recognized by the appellant. Learned counsel submits that his client had the right to treat the agreement as terminated, more particularly under clause 45B Roman 2 of the dealership agreement. It appears that after 30th September 2010, the appellant stopped supply of kerosene oil to the partnership firm. It is now continuing the supply by virtue of an interim order passed by this court and in the writ and continued in appeal. The learned trial judge made the following findings. The appellant could not refuse the license of the first respondent under the 1968 control orders. They could not refuse reconstitution of the partnership firm without a no objection from Susila Roy, the seventh respondent. Susila given the liberty of establishing her civil rights in an appropriate forum. Then our views, my lord. Initially, CROI was carrying on business as a proprietor. The appellant granted her a license to deal with in kerosene oil. On 27 September 2001, CROI took her son, the second respondent, as partner. The business was reconstituted into a partnership firm. The appellant readily granted a fresh dealership license under the 1968 order to the firm. On 24 July 2009, the partnership was further reconstituted by induction of the second respondent's wife, Nisha Roy, the third respondent, as partner. This was also accepted by the appellant by granting the reconstituted firm a new license on 29 July 2009. Again, after the death of CROI, the surviving partners have reconstituted the firm with the second respondent and his wife, Nisha Roy, as partners. The heirs of CROI, except one daughter, Susila, have issued no objection certificates. The stipulation in the dealership agreement that on the death of a partner, the agreement between the appellant and the dealer would stand terminated is not a very fair clause. But, my lord, kindly read it, but it is not illegal. So it may not be a fair clause, but it is not illegal. It is not illegal because, in our opinion, any person can choose to do business with a firm with a particular constitution. So the division bench is saying that it may not be a fair clause, but it is not illegal. I can always bind a particular firm that once this firm goes, if any further reconstitution, I will have the first right of refusal whether I will do business or not. So it is not illegal in our opinion. Any person can choose to do business with a firm with a particular constitution. This is, my lord, the point here. It is true that upon the death of a partner, a partnership firm may be dissolved or it may be reconstituted. There is a state of uncertainty in it. Any person doing business with it is unable to ascertain. In case of its reconstitution, the credentials of the future partners of the firm. A firm is not a juristic entity. So an agreement of dealership with a firm is an agreement to do business with individual partners of the firm jointly and severally.
Yes.
Kindly mark this, my lord. Therefore, when a partner dies, the person doing business with it may or may not be willing to do business with the partners of the reconstituted firm. So this explains, my lord, why it is not illegal. This may not be a fair clause, but for the reasons given, my lord, by the Honorable Division Bench, it is not illegal, my lord. So these are the reasons, my lord, the firm, because when agreement is entered, it is with the partners of the firm. Then page 134, my lord. The appellant is a statutory body. It is enjoined with duty to act fairly and reasonably in contractual matters. It should not act arbitrarily. On the contrary, its actions should be rational and just. For the appellant to insist that the agreement would permanently stand terminated on the death of a partner is an extreme mistake. It would be reasonable if for the time being it was terminated. Thereafter, the partners of the reconstruction firm and the appellant should have been given an option of entering into a fresh agreement. So this option was given, my lord, in extension, my lord. They have given several opportunities to reconstruct, but they are adamant, my lord, that that particular policy circular they are not bound to follow, my lord. In this case, there is no complaint regarding the services rendered before or after the death of CROI. The appellant has permitted the firm to reconstruct itself from time to time. It has renewed licenses of the reconstructed firm for a long period of time. After the death of CROI, the firm has been reconstructed with the second and third respondent as partners. The appellant should not be concerned as to the dispute between the second respondent and his wife, half-sister. The appellant ought to have examined the past and present performance of the firm with regard to its business of a license under it, while considering grant of a new license. In those circumstances, this court upholds the decision of the appellant to terminate the agreement. So, my lord, based on those findings, that my lord, it is not illegal. It may be unfair, but it is not illegal for the reasons given there, my lord, in the next few lines. And then, my lord, the court upholds, my lord, that the decision to terminate has been upheld, my lord. But by virtue of a status quo order in this writ, the respondent firm continues to be a dealer of the appellant. It shall continue to do so on a temporary basis. The appellant is to take a decision as to whether it will renew the dealership with the reconstructed firm first respondent on a permanent basis, on the basis of the above observations and after taking all relevant factors into consideration within 1 year from date. So, my lord, the division bench has remanded matter back to the authorities, my lord, that whether we will reconstitute or not, because they have refused to, my lord, come to terms with us. They are saying that policy circular is not binding there. So this, after 1 year, my lord, this was decided against, my lord, since they have not submitted the reconstruction proposal by following the, my lord, the requirements we have mentioned. They have not submitted the original no objection certificates, my lord. They have not submitted the original deed of dissolution. They have not submitted a no objection or a consent from the Susila Roy. The family tree we have demanded, that has not been given. So those are the requirements, my lord. Now, well, they write a letter, my lord, page 100.
Only left Susila.
Only Susila has been left, and my lord, even the other partners who have supposed to give a no objection, those original no objections have not been submitted. Photocopies are there, they have not submitted, but all those have been returned. So it was never resubmitted. Because, my lord, after page 100, my lord will see, after page 100, there's no further correspondence. The other, after page 100, when we returned the entire document to them for resubmissions, they did not resubmit. They submitted that it is not required, and they submitted that, my lord, the page 97, my lord. Page 97. And we have returned at page 100, we have returned.
Then after page 136,
then kindly text on page 136. After this division bench order, page 136, my lord. This is to inform you that the Honorable Division Bench, High Court, Calcutta, suggests the Indian Limited is to reconstitute the firm without continuing partners, with continuing partners. This is to inform you that Honorable Division Bench, High Court, Calcutta, vide our case number such and such, that Indian Oil Corporation is to reconstitute the firm with continuing partners consequent to death of one of the partners within 1 year from the date of the order dated such and such. Now, this was not the order. Now, they are taking only one part of the order. The legal heirs of Mr. CROI have already submitted NOC to you, which were submitted earlier accepting Susila Roy, one of the daughter, residing at Siwan, Bihar, and Honorable Division Bench, High Court, Calcutta, directed that Srimati Susila Roy has to seek civil suit to establish her claim and may claim her share in the firm within 1 year from the date of the order. The reconstitution processing fee of such and such was deposited with you, vide our receipt number such and such, along with our earlier proposal, which you did not accept. and resulting which we have to remove the Honorable High Court Kolkata and WP number such and such. In view of the above, please reconstitute the form, and we are submitting in current format another along with other documents of existing partner except late CRO. But this is what they have submitted, page 137 onwards.
Yes.
What they have submitted is, my lord, from page 137 to 140, my lord. Kindly text, my lord, 139, page 139. Serial number 5, my lord. Relinquishment deed, NOC from nominees legally as deceased proprietor, not applicable. They have said it is not applicable.
Serial 140 serial 4, deed of dissolution has been submitted.
Copy serial number 4 succession certificate.
No, my lord. 140, page 140.
140.
Draft copy of
Draft
dissolution.
copy of dissolution.
Existing partner. That was submitted, my lord. Draft copy of the deed of proposed partner is submitted. All NOCs were earlier submitted, my lord, in original email. Anyway, that can be submitted. We are ready to reconstitute.
So, my lord, I stand corrected in that case, my lord. What has not been submitted is the no objection certificate in original, and my lord, the no objection from Susila Roy. Now, my lord, page 206 is the impugned order, my lord, after this.
Two zero
6, my lord. Kindly text page 207, my lord. The fourth paragraph, my lord, from second paragraph from bottom, my lord. A proposal for reconstitution of the form. Fourth from top. A proposal for reconstitution of the form by Sri Binoy Kumar Roy and Srimati Nisha Roy was again received by this office on 12th August 2010, which was returned video or later under reference dated on the grounds that the application for reconstitution was not made in the specified format as per the extant policy, and B, family tree of late Sierra was not provided. No objection certificate from legal heirs of the late Sierra were not submitted in original. Since then, you have approached various courts for continuing operation of the dealership, avoiding reconstitution of the firm of Messrs. Roy and Company as per the extent reconstitution policy corporation. And hence, this office could not proceed with the processing of your application for reconstitution of the firm, Mrs. Roy and Company, inasmuch as the writ petition being WP number was disposed of by the Honorable High Court at Calcutta by judgment and order dated such and such, thereby allowing the writ petition. The order dated 1st September 2011 was assailed by the corporation in APO number such and such, which was disposed of by the Honorable Court by judgment and order dated such and such. It has been observed in the said judgment and order dated 7 December. It is as follows. Now, I'm not placing this, my lord, has already, it has been placed before my lord, previously, my lord. 208 first paragraph, my lord. Again, after the death of C.R. Roy, the surviving partners have reconstituted the firm with the second respondent and his wife Nisa as partners. The heirs of C.R. Roy, except one daughter, have issued no objection certificates. Well, this is as per the previous, my lord, this is quote, my lord. This has been quoted from the order of the division bench. This is not the. This is, my lord. Yes, this is the order of the division bench, my lord. You cannot. Not after, my lord, the division bench order was quoted, and my lord, the two clauses 42 and 46 was, my lord, quoted in extenso, my lord, here. Then, my lord, 210 is the our finding, my lord. In view of your failure to submit a proper reconstruction proposal in accordance with the extant policy circular as mentioned herein above, your retail outlet dealership functioning under the name and style of Mrs. Roy and Company is terminated with immediate effect. You are hereby advised to hand over all equipments. So we have terminated, my lord, based on the findings of the division bench as well as, my lord, the.
What is the findings and direction of the division bench?
My lord, the finding and.
Verify the business.
My lord.
Verify the business.
My lord, the division bench has said it was left to the all marketing company whether they will.
The appellant ought to have examined the past and present performance.
This is one part, my lord.
Of the firm,
my lord,
with regard to its business of a license under it while considering the grant of new license.
My lord.
That is your direction.
While considering, my lord, the other aspects, my lord, this aspect needs to be considered, past and present performance.
Yes.
So, my lord, so for past and present performance, my lord, we have said that we are insisting on the policy because the past and present performance definitely come if they comply with the policy circular. Now, if they have not complied with the policy circular.
No, your policy circular and your decision regarding the appellant for termination of agreement, everything is correct.
My lord.
Appellate court has directed you. But your decision is required whether the action or the performance of the business has been anywhere has been regard to the business of license under the consideration grant of new license.
My lord, I will.
Past and present performance of the firm.
That is not reflecting here in the order.
Yes.
But what I'm saying, my lord, that will definitely be considered had they, my lord, complied with the policy requirement under the policy circular. Because if the because the genesis of this is, my lord, the non-compliance of the policy circular. Now, if they suppose if their past and present performance, there is no dispute with regard to the past and present performance. Then should we skip, my lord, give away my policy
This
circular?
is your argument. I want this in black and white in the order.
My lord. So, my lord, my submission will be on in this score, my lord. Only that should have been considered had they complied with the policy circular. But that is one aspect of the matter. But suppose if, my lord, if they have not made the basic requirement, they have not fulfilled the basic requirement because the agreement has come to an end upon the death of a partner. That particular clause from the agreement is very clear. Now, to revive this, the policy circular comes into play. And, my lord, and what has fallen from the division bench will definitely considered. Had they followed this, fulfilled the requirements, then, my lord, the past and present performance could have also been looked into. Now, here, my lord, they have not complied with the policy circular, which is the, my lord, the genesis of this particular dispute, my lord. Because, my lord, this cannot be considered in isolation. Past and present performance cannot be considered in isolation, my lord. This has to be considered whether the main requirement of the policy circular has been fulfilled or not. I can make a definitely, my lord, the company could have made an observation with regard to past and present performance, but when we have found that the basic condition has not been fulfilled, to take the, my lord, to reconstitute the firm. Once the firm is reconstituted, then only past and present performance can be, my lord, looked into and questioned. But here, my lord, the very basic, my lord, the policy circular has not been followed. Now, in support of this, my lord, my submission, my lord, I rely upon some case law, my lord. I'll rely on some case.
Is that the division bench has made clear,
my lord,
that when you have a specific policy regarding the inclusion of all legal heirs, the agreement must be terminated. But the division bench has acted in otherwise,
my lord,
directed otherwise,
my lord.
Whether this act, this policy, if not followed, whether it affects the business.
The policy,
Yes.
my lord, the past and present performance, my lord, is maybe.
Why past and present performance was noted in the order?
My lord,
Because
definitely,
the honorable court, the division bench has accepted your proposal. Yes, according to the policies, according to the policy decision of the IOCL, the all partner has to be incorporated. All legal layers has to be signed the no objection. One legal layer not signed the no objection. That is why the termination is legal. He has accepted your policy, accepted your term. But
no,
again, given a proposal to them to come with a new policy, new agreement, new fresh partnership agreement. Okay, and examine and directed you to examine prior and present business.
No, division bench said, my lord, first whether we will reconstitute or not with the this present firm.
That is not.
That has to be, my lord. That is
not the direction. You just
my
read
lord,
the
my
direction.
lord.
The appellant is a statutory body. You go to the 208.
My lord, I'll just.
Your order.
No, I'll place the division bench order, my lord. Kindly text division bench order.
Not necessary to go to all the orders. Just
that relevant portion from the.
Yes.
My lord, kindly text page 134, my lord.
Yes.
In those circumstances, this court upholds the decision of the appellant to terminate the agreement. By virtue of the status quo order in this writ, the respondent firm continues to be a dealer of the appellant.
Yes.
It shall continue to do so on a temporary basis.
Yes.
The appellant is to take a decision as to whether it will renew the dealership with the reconstituted first respondent on a permanent basis.
On the basis
on
of
a permanent basis, on the basis of the above observation, and after taking all relevant factors to be taken into consideration within a year from date this appeal is to be disposed of.
Yes, you just read in.
My lord, the previous, my lord.
Just paragraph, page 134. First, start from beginning.
My lord, the appellant is a statutory body. It is enjoined with a duty to act fairly.
Yes.
And reasonably in a contractual matters.
Yes.
It should not act arbitrarily. On the contrary, its actions should be rational and just. For the appellant to insist that the agreement would permanently stand terminated on death of a partner is an extreme step. It would be reasonable if for the time being it was terminated. Thereafter, the partners of the reconstituted firm and the appellant should have been given an option of entering into a fresh agreement.
Yes.
Now, how this fresh agreement is to be entered? That policy will come into play. In this case, there is no complaint regarding the service rendered before or after the death of CRO. The appellant has permitted the firm to reconstitute itself from time to time. These are all past reconstitution, my lord, when they followed the policy circular to the extent so, my lord. It has renewed the license of the reconstituted firm for a long period of time. After the death of CRO, the firm has been reconstituted with the second and third respondent as partners. They have reconstituted among themselves. There are no blessings from the IOCL with regard to this point. The appellant should not be concerned as to the dispute between second respondent and his half-sister. We are not. The appellant ought to have examined the past and present performance of the firm with regard to its business of a license under it while considering grant of a new license. So, my lord, this has to be considered apart from, my lord, other parameters.
Where is your consideration regarding grant of new license?
My lord, grant of a new license.
Business performance.
No, my lord, we have come to the conclusion that since they
have not followed the
policy circular, so question of, my lord, this does not come into picture, man. Because had they followed the policy circular, then only reconstitution is that is one of the, my lord, that is the only requirement so far reconstitution is concerned. Past and present performance is, my lord, as per the division bench order. Policy circular does not say you look into the past and present performance while reconstitution. So this would have been definitely followed. We have definitely given, my lord, our opinion. Had this been followed, the first requirement could have been fulfilled. Because the first initial requirement has not been fulfilled, my lord. So it cannot be on the basis of, I cannot give a go-by to my policy circular. That would have been meant that I am giving a go-by. Now, so far, my lord will not take any judicial cognizance of my submission. Now, when they have not commented on it, there is nothing to say about their past and present performance.
No, your stand has been taken by the division bench to be correct.
My lord.
You have followed
based on the agreement, my lord.
Why division bench has allowed you again reconsidering the matter?
But reconstitute, my lord, whether, first of all, the division said whether we will reconstitute with the first and second and third respondent or not, that has to be looked into, whether we'll do it or not. And then, my lord, while doing so, they also consider the past and present.
Past and future present performance of the business.
This particular clause has been considered by the Honorable Supreme Court also. My lord, on one occasion, I have got a judgment on this matter. It's a reported judgment. Same policies or same clauses have been considered by the Honorable Supreme Court, and the same findings.
One legal heirs was not signed the
Partnership form, one of them passed away. The Supreme Court has said that there is no novation of contract, no new contract has come into between the parties, so this clause cannot be, I mean, they cannot insist for a. It was, of course, that particular issue was on a different point, my lord. There was a arbitration clause, whether writ petition would apply.
whether reconstruction is
My lord, this
under
particular clause,
question.
I'll place that.
But I would suggest, subject to lordship's approval, let him give me the list of those judgments to be relied upon, so that on the next date we can come and finish the matter.
Let him find out. Yes.
I have.
Next day.
Next day, my lord.
Next day, all the judgment.
You just mail him the judgments.
My lord.
No, issue has been more or less settled.
My lord.
Okay, but why this court has to gone through the whether you have followed the direction of division
My
bench
lord.
in passing the regime.
My lord.
That is the only merit in this matter. Okay. Argument on behalf of the Indian Oil Corporation heard in part. Let the matter be fixed. Let the matter be listed on next week.
My lord, any day, my lord.
Next week.
My lord,
Next week, my lord, there are so many.
So what do you want, Mr. Agrawal?
30.
इसको हम नहीं रहेंगे उसकी 25 को नहीं हम हो जाएंगे ये तुम 3 तारीख का
30th is the Thursday.
my lord
No, my
no 27 ये Monday
27, 28 any day.
or Wednesday 22nd my lord this week if possible.
No.
27 my lord then Monday my lord.
Monday I have fixed one matter, I think. Second up. 27. Yeah, second up. 27.
27.
22.
Great.
Which were the petitioner?
I'm for the petitioner, my lord. Mr. Rabiul Islam is appearing. I'm short Passover. I'm praying for my lord.
Passover?
Short Passover. My lord, there is difficulty with my lord. Service upon the.
Next.
May I please your lordship?
Yes.
Well, in fact, this matter was moved when your lordship was not sitting here, my lord. Therefore, this matter has been directed to place before your lordship. Till it is been placed, there was an interim order that the grant of license shall be subject to result of the return. But that is not the case, my lord. In hurry, this order was passed. The case is this, my lord, that kindly come to page 24. A vacancy was declared. I was granted appointment. License was issued to me.
So the order was passed. It is directed the grant of further license.
Further license, my lord. That was
if
actually
any, as regards the said vacancy shall be subject to result of the Further license means?
Well,
Okay.
the vacancy was declared, that is at page 21.
Yes.
My lord, at page 24, there is a document of PLRO regarding conversion of land.
Conversion of land.
My lord.
Plot number 1527.
Plot 1527.
1527.
My lord.
Plot number 1527 is your plot.
Yes, my plot.
Proposed subcom go down.
Yes. Admitted
It was
position.
converted to Sali from Bastu.
Yes, this was admitted position, madam. Kindly see the date. It is of December 2013.
26th of December 2013.
My lord, this notification was of page 21 of November 2022. After, before 9 years before the date of publication of the vacancy notice.
Yes.
The applicant is the daughter-in-law of the person who obtained this certificate. Lordship got my Sri Haradan Mandal. And the applicant who Lordship is Mamoni Maiti Mandal.
Okay.
So she relied upon this document and submitted it, and on the basis of this, her selection was made. Now, my lord, kindly come to page 26. That is the Gram Panchayat who gave permission for construction of the godown to my father-in-law. This is addressed to my father-in-law, that it was given, you are allowed to construct.
Page 26, the certificate of the Upapradhan.
Yes. Tell you I was allowed to construct the. There is no dispute regarding this one. But now the question, my lord, has arisen that this certificate is a forged certificate. My lord will kindly, thereafter I have been granted license, but thereafter a so-called notice has been issued, page 41. My license is already, my lord, next, I am not showing you, lord, that is at page 38, license has been issued.
So-called notice was served upon you.
After license, issuance of license.
Like when license was issued?
License was issued on 14th August 2024.
Yes.
And
30th August 2024, the so-called
notice was issued. No matter I am reading this so-called notice.
Yes.
First paragraph is, my lord, that is FA dealership under such and such was declared. Whereas you have submitted one conversion certificate from the block land and land reforms officer, Kagdi White, this office number, memo number dated 26 December 2013, as supporting documents of possession of land, mentioning plot number such and such in favor of Haradan Mandal, son of Asutosh Mandal, in order to obtain MR dealership license to the office of undersigned, with your application dated 15 December 2022. You should kindly mark the date. 26 December 2013, my father-in-law obtained it, and I submitted it on 15 December 2020. And after one communication has been made from block land and land reform officer, dated 27 August 2024, when it is stated no conversion certificate under section such and such has been issued in favor of Haradan Mandal, video memo number 10. BLRO, I do not know suddenly what happened that they asked the BLRO and BLRO gave this report. Whereas that document at prima facie look, it does not appear that it is a false certificate. Anyway, my lord, I was married to the son of Haradan Mandal in 20. My lord, I stated in my reply. So let me complete this. Whereas from the report submitted by the block land and land form of the Kagdi, it is found that you have submitted a fabricated land conversion certificate of the proposed Sopcom go down, BD number censored to the competent authority. In this conversion certificate submitted from your end, it was claimed that the nature of the land has been converted to Vastu, but till date it appears that the nature of the land is still Barga, and thus recourse to fraudulent way to pass the eligibility criteria for obtaining the separate dealership license. Therefore, it appears that you have obtained the FSI in a fraudulent manner, and therefore you have violated clause 15(4) of the FPS vacancy notification number such and such, and misled the authority by suppressing the fact to become a FPA dealer. Your Lordship got my lord?
Yes.
Therefore, considering the above, read a paragraph number 45(3). Your Lordship kindly mark paragraph 45(3) of West Bengal Targeted PDS Control 2024 as amended. You are hereby directed to so cause why no legal proceeding shall not be initiated against you for such deliberate action from your hand within 5 days. So, my lord, after the license is issued, I can be subjected to any proceeding under control order. There is no such provision in the control order that any proceeding can be drawn in respect of the documents which have been submitted at the time of application. Of course, it may be said that if I have done any forgery, I could have been subjected. I want to skip my life. Then my lord, kindly come to next page 43. That is my reply. In reference to your letter dated 30th August 2024, you are hereby informed that I have obtained a FPS license from a good office on 14th August 2024. But somehow certain disputes were made out in accordance with my papers and documents, which were I had submitted for a good office on earlier occasion. Out of which one conversion certificate to filed from my end with a memo dated such and such, which was issued in favor of my father-in-law since deceased by BL and LRO Office Kagdip, and from where categorically stated that the proposed land which was subject matter of such and such is lying and situated within such and such. So this certificate was obtained. Now my father died. I most informed that in process of such conversion application dated to filed by father-in-law and also obtaining certificate from the office of by my father-in-law, I have no personal knowledge in respect of the subject. I got married with Mahim Mandal in the year 2016. Therefore, the application of the conversion and certificate in this regard are to be completed before my marriage. At present, I being a housewife, most humbly intimate you that the requirement of such query as well as make refreshment from my corner. I submit the papers and documents as per my level best. If anything to be detect any dispute, then it is not produced or procured by myself, and such type of incident is totally unintentional lapses from my part. And I hope your good office may be taken into consideration my present situation. Please certify details of the matter. So my reply was that it was not obtained by me. I have relied upon the documents which were in my custody after my marriage. My father-in-law died, so I can't ask him whether this is a forge or not. But on the basis of this, my lord, this order has been issued. Kindly come to the relevant portion. Page 45, my lord. It starts from 44, but it is 45. Whereas a written reply against so-called suspension notice, third paragraph, my lord.
Yes.
Has received video office docket number such and such, it appears not to be satisfactory, as it fails to reasonably explain the prima facie contravention of provision of clause 15(4) of the vacancy notification dated such and such. Now, I shall come to 15(4). Whereas in order to give a further opportunity of being heard, a personal hearing has been conducted at the chamber of Sub-Divisional Controller in presence of Chief Inspector. Deposition submitted by Srimati Mamani Mahati Mandal at the time of personal hearing, it is revealed that Srimati Mandal has submitted fabricated and conversion certificate of proposed some stop come go down to get the FPS license. Whereas it appears that Srimati Mamani Mahati Mandal, wife of Mahim Mandal of such and such, has violated the terms and conditions of clause 15(4) of the FPS vacancy notice and misled the authority by providing fabricated land conversion certificate. The only allegation is that I have submitted the fabricated land conversion certificate. Now, my lord, kindly come to 15(4) of the vacancy notification. That is at page 23. My lord, you got my lord?
Yes.
Any suppression of fact, here is not suppression of fact, information or incorporation, providing of wrong information. So, you can providing wrong information in the application form or attached documents will be considered as a good and justified reason for disqualification for a candidate or rejection of application with taking appropriate legal action. So, my application has already been considered on the basis of that. Now, what can be done, my lord? I have only one option, that is to take shelter of law that is provided under the statute. Because statute provides, your lordship knows, that I may document showing character of land, as your lordship in the last one shown, as commercial and such and such record of rights is not produced. So it may be considered that this record of right was not produced. Even if I am not sure, my lord, whether this is at all fabricated document or what is that letter of BLRO to the authorities, nothing has been disclosed before me. But all the safeguard, I have made an application, already made an application for obtaining fresh certificate. If the land is of other character, the applicant needs to submit application for conversion on or before the date of application. That was not possible at this picture. And to submit conversion certificate within 3 months from the date of offer of FPS license. So, I have 3 months time to submit this certificate. I have already made application. If I get this conversion certificate, I shall not pay for any interim order at this stage, madam. Because until I satisfy the authority about the conversion certificate, though that is not a mandate in the, your lordship knows there is a marking system. Marking system does not say anything about probably so far as I stand corrected about the vastu of land.
Yes.
But still, since there is an allegation, I should be
Only
fair.
nature of position is the mark.
So I shall be fair for your lordship, my lord, that this order should be stayed for the time being, and let there be direction for affidavit or report, whatever my learned friend wants, so that it can be disposed of after permission of the claims. And in the meantime, if I get the certificate, I shall submit with the authority and I shall place it with my affidavit also.
No. What is the status now?
Now I am a licensee, but I am not operating.
Not operating.
Under suspension.
Under suspension.
Not supplement, it cancel my lord.
Lordship, the report is already here.
Terminated.
I represent the state. Lordship might be.
No, a report, you have to file the report with a copy to them. Otherwise,
I will give them. I have an extra copy.
If they give, then I shall file my exception.
If they want to file an
And let
exception,
it-
they
but
can,
let
but
them-
if Lordship would
let
just
them-
go through the report
Let
once.
them place the documents by way of affidavit.
yes, you file it through affidavit. It will
I am
be
not
better.
asking for any interim order.
Okay. Please take down. Learned counsel appearing on behalf of the state authority submits that the report of the state respondent is ready. He wants to use those reports in the writ petition. Let the report be placed with the record with the affidavit. Let the affidavit be filed within a week.
2 weeks.
2 weeks.
Within 2 weeks.
Yes.
Exception, if any, by the petitioner within 1 week thereafter. Let the
But
matter.
I shall also like to 2 weeks because I have to obtain that certificate.
Okay, within 2 weeks. Full stop. Let the matter appear in the list on 18th of February.
My lord, the orders would be stayed to the state.
No, Lordship, I object to that.
No,
Because we have not
They
gone
will
against
declare,
the law.
they will give appointment to any other candidate in that.
No, we will not give it to any other country.
Then it's all.
Let it be suspended because there is a penal action which is in, procedure. They have violated and we are doing things as per the law itself.
New vacancy is subject to the order of the writ petition. Already order is there.
My lord, that order is no new vacancy. In this vacancy, second candidate will be maybe given appointment. I will only seeking for 1 month protection. That this order will remain, but I am not asking for my continuation of business until I satisfy the authority and your lordship. My lord, I shall not ask for continuation of business. Only no license should be granted.
Then what will happen, your Lordship? The people in those area will not get.
They are
any
already
ration.
getting. They are already getting.
They will not get.
They are tagged with another person.
They are tagged already.
Tagged with another.
They are already
That
tagged.
is not the issue here.
That is not this.
Issue is that whether the state authority is in a position to declare a fresh vacancy or.
That is why, Lordship, I have come with this gazette notification based on which this decision was taken. If Lordship.
Now,
would
what
find-
is the report? You say me the report. Is there?
The report is a long one, Lordship. It goes paragraph wise. So that, but anyway, paragraph 5 of the report straight away says that Srimati Mamoni Maiti Mondol has submitted one conversion certificate from the Block Land and Land Reforms Officer.
That is, that I know.
That has
What
been
is the
presented.
ultimate decision of the state authority?
Now it says, paragraph 7, it says, has been kept under suspension and a show cause cum suspension notice has been issued.
Yes. That has been done.
Yes.
Nothing is there.
My lord, termination, your lordship says not suspension. Kindly see.
Termination.
That is terminated.
Yes,
That's why, yes, kindly see page 45.
So, Mr. Agarwal, what you want now?
I'm only asking for my stay of this order with rider that I shall not be allowed to continue with the dealership.
No, if you use the wrong document.
No, my lord, this is not the wrong document. It has not yet been established. There is a report from BLRO which has not been supplied to me.
But it is
And
there.
what is the
Whether
reason?
you challenge the order before the appellate authority? No.
No, man. This order is not being challenged.
The BLRO report is with
Because-
Lordship's report. It's with Lordship's
Because it was passed on 10 December
We are not
2024
supposed to give him.
and the
We are
license is
supposed to
going,
give Lordship the-
license has been renewed up to 31st December 2024. My application for extension has not been accepted. That is the dilemma, my lord. They have not accepted my extension application, renewal application.
The petitioner has provided false information, Your Lordship, regarding conversion, land conversion.
Everything
This does call for a penal action, Your Lordship. The BL and LRO's report is here with this report. If Lordship might want to see just once, I will put it on affidavit. But Lordship has not been supplied to us. It just says, in reference to the above mentioned subject and reference, it is to inform him that after scrutinizing of office records, it appears that no conversion certificate under Section 4C of WPLR Act 1955 has been issued in favor of Haradhan Mondal.
I understand. It's a Borgaland.
And,
Borgaland.
and Chapter 9, the Kolkata Gazette, which deals with this, dated 1st August 2024, Section 45(3). If the licensing authority on a complaint received against a dealer or suo motu is prima facie satisfied that such dealer is acting in such a manner which is prejudicial to the interest of the beneficiaries tagged with his fair price shop or may hamper smooth implementation of public distribution or may lead to law and order situation, he may immediately render the license under suspension. And after giving him an opportunity of being heard, if found guilty of any of the contravention mentioned in these orders, he may, for reasons to be recorded in writing, impose punishment of either fine
No, this is
or
2013 order, and that order has been passed under new control order 2024.
This is
What
the
is it?
2024. This,
No, okay, I understand.
this is the 2024 order.
Licenses issued under
1st August 2024.
No. Yes. Well, only condition that they will not issue license to anybody for 1 month or 6
How
weeks.
can
or-
that be, Lordship? 2 weeks we will take
If
to
they
file
get
an
and third
affidavit.
party-
2 weeks they will take to file a reply.
the
The
date has been
matter
fixed
might
by-
come up after another
18.
2 weeks or 6 weeks.
Okay,
Only up to 28th February.
Order cover keyboard. Huh? 2 weeks there. 2 weeks there. Let the matter appear in the list. Let the matter appear in the list on 18th of February 2020. Mr. Agarwal, learned senior advocate for the petitioner, submits that one order of stay is most earnestly required for protect the interest of the present petitioner, in favor of whom the license has already been granted. The said contention was vehemently objected by the learned counsel for the state. Having heard the learned counsel for the parties, also considering the order passed by the subdivisional controller, Kaddeep, South 24 Pargana, it appears to me that the order passed by the subdivisional controller as based on some good presumption and on the basis of a report of the concerned BLNL at this juncture, I find no merit prima facie merit in the writ petition. Accordingly, the instant with the prayer for stay cannot be granted at this stage.
Great. My lord, BLO report has not been supplied to us. And your lordship,
I will deal with
your
it
lordship has
later.
observed, my lord, that
Prima facie, I find nothing. You come on final stage.
my lord, your lordship kindly record that earlier there is already an order that is subject to result of this. My lord, kindly record that. Because otherwise there will be a controversy in the order matter.
That's why I don't want to pass any order. You insisted that I pass.
Then my lord,
Okay,
kindly
let it be maintained.
then let it strike out, your lordship. Last one.
No, that cannot be, Lordship. That is going to
No, because there will be contrary to it.
state for no fault of ours. It's not
That
that
will be
we have
contrary to it. No, one
we have
order has
break
already
the
been
problem.
passed.
He has come with a now.
If that order is
Lordship,
modified,
if I may just kindly say, I heard what the petitioner said here, Lordship. Lordship, kindly understand, I was not aware because I was married into this family, because it belonged to my father-in-law. Can this be a ground for providing a false document? Why will how will the state understand?
that has not been proved.
I am not going to hear about the merit of this matter. This is the merit. This is
Well,
the
from
merit.
there verified.
We have got a false document.
And you have not submitted the document, that is the BLO report to the petitioner before hearing.
Lordship,
That
I will
is
give
a-
it to the affidavit.
Well, before it, they have terminated.
Lordship, today I got the copy for the petitioner. Lordship wanted an affidavit. So when I serve the affidavit, I'll serve him.
What he is
with-
submitting
with
from the bar.
With everything.
Okay.
Well, let that portion be, my lord, at least. Then last portion be strike out. Then I,
Let it be there. You have the chance. No issue. Okay.
keep them.
Grateful, Lordship.
My lord, item 27, your
Next.
27, your lordship passed not today. It should be, my lord, after 1 week because service to the state was not accepted by them. There
Okay, not this week. Item number 27, not this week.
not this week, and your lordship kindly direct me to serve. Otherwise, they will not accept. Sarthak system is, my lord, such that within 72 hours, it will not be received by them. That was the ground for not receiving my application earlier. My lord, unless there is an order by your lordship, they will not receive.
That is the issue.
Yes. Only online, I shall be serving the copy.
Item number 27. That's what- Applicant is directed to serve the copy of application upon the state respondent. And let the matter appear in the list. The next week.
Next.
Next.
May I please, Your Lordship? I'm for the
Yes.
petitioner before Lordship. Lord served affidavit of service, Your Lordship. My Lord, this is with regard to, my Lord, appointment of a AMA dealership in respect of Lord, the place of vacancy was under Boshirhat subdivision. Adho Choital. My Lord, the state has failed and neglected to issue appointment letter since 1983. 83. Initially, my Lord, the brief facts is stated in the order itself, the last annexure. Initially, a vacancy arose in the year 83. Thereafter, they subsequently, Your Lordship, they withdrew that. In 1990, again, they issued a vacancy. That also being withdrawn. Subsequently, again, it was a fresh vacancy was issued, declared, and their petitioner, Your Lordship, appeared, and she was found to be the most successful candidate. That was also
When it was declared lastly?
last time. It was in 2017.
2017.
Yes. Last time it was declared on 2017. That was on the basis of a notice. I was being asked to make a representations, come up with all necessary applications. And I did that. In Form C, I filed my documents and papers. And we came to learn very recently that it was alleged that no candidates were found to be suitable. This finding is totally not incorrect, because in 2017, the inspection was held, inquiries being committed, and thereafter again a fresh notice was issued, wherein it was stated. Yes. This is at page 16, Your Lordship. Notice for inquiry at page 47. Kindly, Your Lordship, come to this.
Yes.
47. Subject inquiry against notice for filling up vacancy of Emma dealership at Muddha Choital, PS Minakha, under Boshirhat subdivision in district of this. Notification number this was initially of 2007, but prior thereto and read with memo number this 17 and 2019. Please refer to above due to unavoidable circumstances. In supersession, the previous notice mentioned under reference, the undersigned is to inform you that an inquiring officer will arrive at your respective go down on 7/8/2019 around at office hours for causing an inquiry against your application submitted earlier for appointment of Emma dealer at Muddha Choital against Emma vacancy number 2007. This is still going on. I don't know why they are. It's not that, Your Lordship.
What happened after 2019, after this letter?
They had recently we came to learn, Your Lordship, that the subdivisional controller has rejected all the applications of all the applicants who made applications for appointment, and it was sent before the higher authorities for necessary orders. Lord, kindly, Your Lordship, take the last annexure, the last page, 83. 83. Though it starts from 81, wherefrom it would be evident, Your Lordship, that initially vacancy started in the year 1983, and these things are going on. 1983, thereafter 1990, thereafter again, thereafter it's going on. And the last at page 83, Your Lordship, the finding is that the selection process that continued in pursuance to the impugned notice dated 6/8/2007 must, in my view, be allowed to reach its logical conclusions, and the respondents shall be at liberty to appoint the selected candidates as dealer in accordance with law as early as possible. That's whatever it is. But it was not done. Every time they are coming up with a vacancy notifications, and at their whim, Your Lordship, they are cancelling. Well, let there be a directions to call upon the respondents to come up with the reports. At least all the inquiry reports that has been. Yes, Your Lordship, served upon all. They all received it also.
Who is appearing? No one is appearing.
This is the first time it is appearing before Your Lordship. And the petitioner was found to be the most suitable candidate, and her name was referred for approval before the higher authorities way back in the years 10/6/2015, pursuant to earlier inquiry. Thereafter, that inquiry was abandoned, a fresh notice was issued, and thereafter again inquiry was caused in 2019. And now they are saying that no suitable candidates are there. So again, they sought for cancellation of the entire appointment. But how it was found, I don't know, but I do have a copy of it. I'm not going to place it. The Lordship would be kind enough to look into it.
What is this?
This is a notice when we had the petitioner was found to be the most suitable candidate. At an appointment, it was sent for approval before the higher authorities. That is way back in the year 2015. And after cancellation of this, a fresh inquiry was conducted. And again, when the appointment were to have been given to the most favorable candidate, again they sought for.
You have not placed this matter.
No, but we had submitted before Lordship. This in paragraph we have stated that.
Let one appear on behalf of the state. Yes. Mr. Suman Sengupta may be appeared in this matter. In spite of service, none appears on behalf of the state respondent. Learned advocate, learned Suman Sengupta, learned advocate, who represent the state in these matters. He is requested to appear in this matter along with Mr. on behalf of the state authority. Petitioner is directed to serve the copy of the writ application along with the annexures thereof to Mr. Sengupta. Concerning the submission of the petitioner as the matter of appointment of the FPS dealer is pending since the year 2007. I think it necessary to issue direction upon the state to file an affidavit, file a report in the form of affidavit within 6 weeks. Reply, if any, by that petitioner within 2 weeks thereafter. Let the matter go out of the list. Parties are liberty to mention. Kindly fix the date. Item 51 is very. There are several matters are there. Yeah, okay. Mention I will continue the list tomorrow.
Yes, similar flavor. Next matter, my lord. I will not there in court tomorrow, my lord. Actually, can you take it up here? Next matter, item number 30.
30. Day after tomorrow.
Yeah. Oblige.
I will take up tomorrow all the matters. Not this week. Item number 51. You asked for the petition. Very well, not this week.
Already monthly list is the book. Yes, we the children.